Okay, is Mr. Sanders at the main jail?
I'm here, Judge.
Okay, how you doing there? Do you need more time?
No, we can go ahead and start. I'm talking to some people, but I'm almost
there. All right, well, I'm just going to take a brief recess, and I'll be back in a couple minutes. Everybody, my name is Judge Kim Teresa Malika. You're in First Appearance Magistrate Court. Today you're going to be informed of the charges and we're going to determine if there's probable cause. Please keep in mind today is not your trial date. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. We have Mr. Sanders, who's at the main jail, and we have Ms. Chase, who's here in the courtroom with me. If you have a private attorney, please let me know. When you step up to the podium. We are going to take a couple cases out of line. First person is Roberto Rios. Thank you. Okay, counsel, if you can announce your appearance for the record.
Alexandra Buckle on behalf of the state, Your Honor.
Okay, defense.
Julie Chase with the Public Defender's Office. Judge, I was
Mr.
just
Sanders?
reviewing that one.
Oh, thank you, Mr. Sanders. Good morning. If you could announce your appearance.
Austin Sanders, Public Defender. What page are we on, Judge?
I don't know. It's Roberto Rios. Can someone tell me what page?
22.
22.
Page 22.
Yes, does he have private counsel?
I don't believe so.
Say that again?
They didn't put the case number. It's not a case.
Yes, state.
If you look on the finding, I don't know if the clerk's office called it. There's no case number on your finding.
Oh, okay. I have 183247 CF10A. Is that
That's
correct?
the correct case number, Your Honor.
Sorry, can I hear that one more time?
183247.
Do you want me to put it on there?
Yes, please, right?
Okay, no problem. No problem. Thank you for letting me know that you wanted that.
Judge, he is represented by the Public Defender's Office. He was originally charged as a juvenile, but we direct filed him as an adult. So this was a not-in-custody KPS.
Okay. All right, are you Mr. Rios, sir?
Yes, ma'am.
Okay, you gonna waive formal reading?
Yes, Judge.
Judge, I don't know what the charge is.
You might wanna call Ms. Chase on the phone.
Okay, what page is it on?
22.
22.
22?
After this, we're gonna take Damian Moss Solomon. Okay, sir? You're welcome. And then we'll take Mr. Odom, last but not least. Okay.
Okay, Judge.
Okay, you ready? All right. So the court does find probable cause. Let's talk about bond on counts 1 and 2 and any special conditions that the state is requesting.
Judge, the state is asking for no bond. We're asking that he be held until he's seen in front of Judge Culver for an Arthur hearing. He is facing 2 life sentences.
Okay, so you'd like me to make a finding of proof, evidence, presumption, great?
Correct.
Okay, defense?
Judge, I was just trying to look and see who from our office was appointed this case to see if they may want to be here, but at this time, I just reserve any argument for an Arthur hearing.
Okay, I've reviewed the paperwork, the affidavits filed in your case, sir, and I do find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, on counts 1 and 2, you're going to be held no bond. This order is without prejudice for you to file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. I'm also going to order no contact with the alleged victim, direct or indirect, with the initials MK and MK's family. Direct or indirect, sir, means no contact in person, calling from the jail, writing, texting, blogging, anything on social media, or contact through third parties, okay? Anything else?
No, Your Honor, thank you.
Okay, that's it. Thank you. Okay, we're going to call Damian Moss Solomon. He has private counsel here. Mr. Sanders?
Morning, Judge.
Good morning.
Jamie
how
here
are
on
you?
behalf of Damian Solomon.
Okay. Do we need to put the victim, the initials in here or family? I just want to make sure that it has the victim's initials and their family on that order you just gave me. Okay, I just didn't know if you wanted to put it on there. That's fine. Okay, thank you. All right, I'm sorry, counsel, can you say your appearance again?
Jamie Eard on behalf of Damian Solomon.
Okay, state, announce your appearance for the record.
On behalf of the state.
Okay, Mr. Damian Moss Solomon, you have one charge, sir, of aggravated battery with a deadly weapon. We need to talk about bond. These are all domestic violence. And counts 2 and 3 is battery caused bodily harm. Court does find probable cause. Okay, state, what are you asking for with bond with regard to count 1, 2, and 3?
$1,000 on count 1, $5,000 on 2, $2,500 on 3. No victim contact.
And Your Honor, if I may, Mr. Solomon is gainfully employed for the past 5 years as a repair manager for a property management company. Your Honor, this management company oversees over 35 properties, and he's the manager for that property. Your Honor, he has 2 children, one outside of this marriage, who is currently in university and is dependent upon Mr. Solomon's financial assistance. Your Honor, moreover, just a plain read of the probable cause affidavit indicates that Mr. Solomon was just trying to exit the property, Your Honor. Once the victim was outside of the property, he tried to lock the door to have no contact with her. She found her way into the residence. Mr. Solomon then tried to exit the residence. Although these facts are undisputed based on the probable cause affidavit. Mr. Musalman was trying to exit the property when the victim was chasing him. The only reason that the victim was able to come into contact with Mr. Musalman was because the gate was closed, and while Mr. Musalman was waiting for the gate to be opened was when the victim jumped in front of his vehicle while he was trying to exit. These facts are undisputed based on the probable cause affidavit. Moreover, Your Honor, the victim in this case, signed a non-prosecution affidavit, and she indicated to law enforcement that she's not going to press any charges against Mr. Musalman. Again, these facts are undisputed based on the officer's probable cause affidavit. Your Honor, so in this case, we'll be asking for ROR, Your Honor. There's no danger. I believe a no contact order would be sufficient to satisfy the state's concerns. But, Your Honor, the victim, I mean, just based on the facts, Your Honor, I mean, it's clear that Mr. Musalman was trying to exit. The victim even signed a non-prosecution affidavit to law enforcement, and she told law enforcement that she does not want to press charges against Mr. Musalman. So, Your Honor, based on those facts, we ask that Mr. Musalman be allowed to be released on his own recognizance, along with a no contact order.
Your Honor, counsel's representation that the alleged victim jumped in front of the vehicle is not accurate. She was standing in front of the vehicle when Mr. Musalman accelerated, striking her. This was confirmed by a witness and video surveillance. Additionally, Your Honor, and the reason the state is requesting the bonds that I am, is in 2017, Mr. Musalman was arrested for battery against the same alleged victim, and that was dropped. In 2010, he pled a felony charge down to misdemeanor domestic violence battery against the same alleged victim, and he received a withhold.
And, Your Honor, in 2017, just to address that case, Your Honor, the state filed no charges on that case based on the facts, Your Honor. It was a similar situation in which the victim was trying to enter the residence and Mr. Musalman closed the door on her. Those facts are also undisputed in the 2017 case. The state filed no charges based on those allegations. Your Honor, in this case, we'll just be asking for release on his own recognizance based on the obvious facts, based on the fact that Mr. Musalman is gainfully employed, lack of criminal history. We'll just be asking for it to be released on his own recognizance, Your Honor. Moreover, that's it, Your Honor. We're just asking for it to be released on his own recognizance based on those facts.
Okay. Thank you very much. The court is going to set on count one a $10,000 bond, $5,000 on two, $2,500 on three. No victim contact, direct or indirect, with the alleged victim with the initials, good morning, VMS. No firearms, ammunition, or weapons. He's to surrender same to the local police department immediately upon his release. He's maintained 1,000 feet from the victim's work, home, and school, if any. And I'm going to put a GPS level too. Thank you.
And, Your Honor, one more issue with the no contact order, Your Honor. The residents of 754 Southwest 170th Avenue is actually, Mr. Musalman owns this property along with his mother. May I approach with the paperwork indicating...
Does she live there as well?
Your Honor, I'm not sure if she is currently living there, Your Honor.
They say the defendant and victim are married. Tell you what, let him take it up with Judge Cohen. He'll be back on Monday, okay, sir?
Okay, Judge.
That's without prejudice, obviously.
All right, thank you.
Thank you. Okay, Mr. Odom.
Is it a felony, Mr.
Troy Alexander King. Good morning, Your Honor. Good morning. Hello, Ms. Jackson.
Lawrence and Mr. King.
Hey, are you Mr. Troy King, sir?
I'm just looking to see.
So page 11.
It might be here in the bottom of these. Let me finish. Let me take these up. I'm thinking it's going to be on one of these because I haven't come across that one yet. And I have all these, so it must be right.
Troy King on page 11.
Okay, sir, you're charged with the municipal ordinance trespassing. Bond set at $25. Court does find probable cause.
Judge Wood asked the court in this particular incident to get involved. After reading the PC, it appears the allegation is that he was taking a shower without permission inside of a assisted living facility. I don't see anything what indicates any other negative involvement with the facility and or residents of that facility. So I would ask the court to consider adjudication time served in this matter with court costs and no return to this facility and you know, no return to, I guess, any facility that does not allow him the express or written consent to be inside and or utilize their facilities.
Here's the problem, he was issued a trespass warning one time previously. So court will give him an adjudication 3 days, Broward County Jail, credit for time served.
Mr. King, did you hear the court's offer? Hit the, there we go.
Yes.
Okay, the court is offering, if you wanted to resolve today, you don't have to, but if you want to resolve today, the court is offering you adjudication with, I believe, credit for 1 day served with court costs. Are you interested in that offer?
And no return to
And no,
this place.
and no return to the facility.
All right, yes.
Okay, raise your right hand. Do you swear and or affirm to tell the truth?
Yes.
Is your name Troy Alexander King, sir?
Yes.
K-I-N-G?
Yes, ma'am.
It's my understanding you wish to waive your right to a trial in this case.
Yes, ma'am.
Anybody forcing you to do this?
No.
Are you under the influence of any drugs, alcohol, or medication that would affect your ability to understand what's going on here today?
No.
Have you ever been treated for a mental illness?
No.
You understand that if you're not a U.S. citizen, plea of his charge could result in deportation proceedings and affect your ability to remain in the United States, sir?
Yes, ma'am.
Okay, you understand that you cannot return to Kelly's assisted living facility?
Yes.
All right. You want to plead no contest to trespass after warning? No contest,
No,
not
ma'am.
guilty or guilty?
No, ma'am.
You don't want to plead no contest?
No, ma'am. I would go ahead and try to bond out because I thought I would be able to get time served, but 3 days I work, ma'am, so 3 days is like too much for me.
All right, $25 bond. No victim contact, direct or indirect, and you're not to return to Kelly's assisted living facility. Thank you, sir.
And Judge, if I may, just understanding that he is employed now, it does appear that he has a residence at least on file. I know 25, although seem nominal to some, may be a lot for Mr. King. Would the court consider releasing him on his own recognizance?
What's his address?
Mr. King, do you have a stable address?
Yes.
What's your address, living address?
730 Northwest 15th Court, Fort Lauderdale, Florida, 33311.
And do you receive mail correspondence there?
Yes.
If you were to get notice, which you will, to return to court, can the court depend on you honoring that notice and returning in the future to your court appearance?
Yes, sir.
Okay, sir. ROR, no return, okay? No
Thank you.
contact either. You're welcome.
Thank you, Judge.
Peter Metzler?
He's on page 12.
This you gotta add and the family. Is that the one the special prosecutor did? Oh, okay. I'm sorry.
North Broward.
Go ahead for North Broward.
Okay, Peter Metzler, please.
1 second. Peter Metzler. We're gonna have to put him on recall, Your Honor.
No problem. For how long do you think?
Just until we get him down from the unit.
All right, let us know, because we have Mr. Odom, a special public defender waiting, okay? Private attorney. Thank you. Joseph Curtis? Joseph Curtis, please.
Is on page 14 at also North Broward, so he may also be a recalled as well if they don't have him.
Joseph Curtis. Does anybody know where Joseph Curtis is?
North Broward.
Okay, is there a deputy at North Broward?
He's approaching, Your Honor.
Okay, thank you.
He's approaching right there. Yeah. Here he is, Your Honor.
You know what?
Aggressive
Okay.
panhandling.
It says it on my PC though. Okay, are you Mr. Joseph Curtis, sir? Are you
No.
Mr. Joseph? Who is this? What is your name, sir? Sir, what is your name? Deputy at North Broward, please.
Yes, ma'am.
Who is this standing here? I'm asking him his name. He's not responding.
Paul Burgess. I didn't know you were talking about. I'm sorry, ma'am. Paul Burgess.
Paul Burgess, he's on the felony.
Paul
docket.
Burgess.
Okay.
I don't know.
All right, Deputy at North Broward, let me ask you, do you have Joseph Curtis?
Joseph Curtis. He's another one coming from the mail permit. They're having an issue over there.
Okay, that's fine. And this gentleman's name, what page is he on? I'll take him out of turn since he's here. Huh?
He's on page
17.
Page what?
17.
Okay, and his last name?
Burgess.
B or V?
B. Boy.
Pay attention.
What is your first name, sir?
Ma'am?
Your first name is Paul?
Paul.
Unfortunately, I don't have them. What page are we on now? 2?
Comment on that?
Hey, I found you, sir. Okay. All right, sir. Your name is Paul Burgess Jr.?
Yes, ma'am.
Judge, I'd waive a reading at this time.
Okay. All right, sir, you have an ad charge. Court is going to find probable cause. The court is going to order no victim contact, direct or indirect, with the alleged victim with the initials JTC. That means, sir, no contact, calling, writing from the jail, in person, calling, texting if you do get out of jail, and no contact via third parties and nothing on social media. Do you understand?
Yes, ma'am.
All right, let's talk about bond.
Our state is going to be requesting a $50,000 bond, pretrial release with a GPS monitor, level 1.
Okay, defense?
Judge, I understand he's currently incarcerated. Obviously, he's not working at this time. I know there's a bond amount on his other case, which is $3,500. He obviously hasn't been able to post that bond. I'd ask the court to consider his financial circumstance and set something a little lower that maybe he can afford.
Okay, based on the allegations here, the court is going to put him on GPS level 1, no victim contact. And based on what I'm reading here and the totality of the circumstances, the court's going to set the bond at $100,000. Thank you.
Okay.
Okay, Deputy North Broward, let me know when we have those people. Do we have Corey Neal?
1 second, ma'am.
He is on page 15 of your docket, Your Honor. He's at Maine.
Oh, he is?
At least that's what the docket's saying.
All right. Okay, Corey Neal, please. Good morning, Mr. Neal. You are charged with resisting without violence. Court does find probable cause. Bond set at $500. Mr. Odom?
Judge, and I understand the court has made a ruling on PC, so before I get into my...
No show a calendar call, so.
Yeah, not, cause I'm talking about PC, well, thank you, you
Okay.
took me back to the original issue, so it's already been found. Mr. Neal, are you interested in resolving your case today? Judge, would the court be, to get involved in this matter, if the court was able to, I'm not sure, to read the original probable cause affidavit?
Yeah, let me read it. You don't have a copy, do you?
Just electronically, Your Honor, I apologize. But you're more than happy to,
Sure, can I see it?
see if I came
It'll
out
be a
of
lot
it.
faster than me
Oh.
pulling it up.
No, I came out of it, but I will pull it back up real briefly here.
Stout.
Six.
Okay, here you go. Thank you for finding that for me. It was a lot faster. Thank you.
Education time served, there appeared to be no negative violence or what bracing, tensing, etc. towards the officer. It appears the resistance came solely from the officer attempting to do a stop of some sort, and then Mr. Neal fleeing and hence getting apprehended the next day.
Okay.
Which I would take note of. Apparently
Okay,
there was.
adjudication time served.
Mr. Neal, are you interested in that offer, adjudication time served, to resolve your case today?
$78.
Yes, sir.
That would include court costs of $78 to be paid within 6 months, Your Honor? Okay. Do you want to accept that offer?
Yes, sir.
Okay, raise your right hand. Do you swear and or affirm to tell the truth, Mr. Corey L. Neal, N-E-A-L?
Yes, ma'am.
Okay, that's how you spell your last name?
N-E-A-L, yes, ma'am.
Okay, put your hand down. It's my understanding you wish to waive your right to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Are you under the influence of any, or on any medications that would affect your ability to understand what's going on here today, sir?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to discharge could result in deportation proceedings?
Yes, ma'am.
Understanding what I just explained to you, you want to plead guilty, not guilty, or no contest to resisting without violence?
No contest.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate your time, serve you, impose court costs, which I have to by law, of $78, and the court will give you 6 months to pay. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed.
Judge, I'll rotate back. I gotta run the circuit side.
Oh, okay, go ahead. Thank you, sir. You're done with this case.
Okay, thank you very much.
Have a good day. Christopher Ramon Diaz. Okay, Mr. Diaz, you are charged with 1 count, battery, second or subsequent offense, domestic violence, we need to talk about bond. Count 2 is domestic battery by strangulation. Count 3 is false imprisonment. Those first 3 we need to talk about bond. Then we have count 4, criminal mischief, over $1,000, which has a $500 bond. Count 5 is operating without a valid DL, $25 bond. We have assault, $100 bond. Count 7, possession of cannabis over 20 grams, $1,000 bond. And count 8 is neglect of a child without great bodily harm. We need to talk about bond on 1, 2, 3, and 8. State?
Your Honor, on count.
Oh, wait, court does find probable cause. Sorry about that.
Your Honor, on count 1, I'm going to be requesting bond in the amount of $15,000. On count 2, I'm going to be requesting bond in the amount of $50,000. Count 3, $25,000. Count 8, $2,500, and I'll wait to advise court.
All right. court is gonna order no victim contact, direct or indirect, with the alleged victim. I believe it's the initials KD, Mr. Linder?
Yes, and Your Honor, I apologize. I'm also going to be requesting pretrial release with a GPS level 3.
Okay.
Judge,
Hold on one moment. Sir, there's no victim contact, direct or indirect, with the alleged victim in this case, with the initials KD. That means no calling, texting, writing, anything in person, anything on social media, and nothing through third parties. And that even includes contact with not calling from the jail. Do you understand?
Yes, ma'am.
All right, thank you. Okay, go ahead, Mr.
Your Honor,
Sanders.
Judge, he's lived here his
Hold
entire
on one
life.
second, Mr. Sanders. North Broward's calling me, okay? I'm sorry, I apologize.
just advise you that Mr. Peter Metzler is here. He told me to let you know when he came.
All right, let him have a seat now. I'm sorry, Mr. Odom, his attorney, had to go over to the felony side.
No problem.
So just
Thank
have
you.
him have a seat. That's for the other ones as well, okay? Thank you.
Thank you.
All right, I'm sorry, Mr. Sanders. Go ahead.
Sure. Mr. Diaz has lived here his entire life. He's 25 years old, so he's not a flight risk. He has one child here. As far as the state's asking for ankle monitor, if that's the case, asking that the monetary be reduced substantially, he can make $1,000, maybe $1,500 at the most for a bond. And so we're asking for $5,000 on count 1, $2,000 on count 2, $5,000 on count 3, and $2,500 on count 8.
Okay. All right, this is what the court's gonna do, sir. No victim contact, no firearms, ammunition, weapons, and if you do possess any, you surrender them to your local law enforcement, police department immediately upon your release. You're to maintain 1,000 feet at all times from the victim's work, home, and school, if any. GPS level 2. Court is gonna set on count 1, a $10,000 bond. Court's gonna set on count 2, a $50,000 bond. Court is going to set on count 3 a $10,000 bond. Court is going to leave the bond on count 4, 5, 6, and 7, which are $525, $100, and $1,000. And on count 8, the court's going to do bond at $1,000. Thank you. Have a good day, sir. Next one's going to be Troy Everett, please. Troy Everett. Good morning, Mr. Everett. You have one count of burglary, unoccupied conveyance, unarmed, touch or strike battery, and you do have 3 capias. Well, it's actually 3 capiases. 2 are for traffic, 1's for a misdemeanor, which is for, so his charges are battery, suspended driver's license, first offense, operating without a valid DL, burglary of a conveyance unoccupied, and battery. We need to talk about bond and the burglary of a conveyance. The count 2 is $1,000. 3, 4, and 5 for the capiases are $2,500 bond, $1,000 bond, and $2,500 bond. The court does find probable cause. He does have a hearing before his misdemeanor judge, which is Division MA, which is Melinda Brown. That is on April 12th, 2018 at 11 a.m. And then he has Division MV for the other capias, which is going to be set in the division. A date has not been set for that yet. Just give me one moment. And he did no show for a hearing on August 2nd, 2017. There's an unserved summons January 3rd, 2018. That's for the battery, the $1,000 bond. And he has a no-show at another hearing on August 2nd for operating without a valid DL. Actually, both of them are on August 2nd for a suspended DL first offense with the $2,500 bond. And then the same day, operating without a valid DL, $2,500 bond. Same judge, Judge Melinda Brown. Okay? Okay.
Your Honor, first, the state is going to be requesting a $3,500 bond on count 1.
Burglary, okay.
Yes, I would
Unoccupied.
Yes. Just to note for the record, the alleged victim on the felony case
Yes.
Is the same as alleged victim as in charge number 4.
Okay.
Your Honor, I'm going to be requesting that the court issue no contact orders for both the felony and the misdemeanor case on charge 4, the unserved summons capias issued by Judge McHugh.
Is that the 17-10121 case?
Yes, ma'am.
All right, what's the victim's initials, please?
SR, and I believe the clerk has the name for the order.
Should this case have gone to Judge McHugh today or no?
No, because the felony, it's going to be before Judge McCarthy because there's a felony attached to it, so.
Okay. All right, sir, so the court's gonna, then I'll let you, tell me what your thoughts are, Mr. Saunders. Sir, there's gonna be no victim contact, direct or indirect, with the alleged victim in this case with the initials SR. That means no contact in person, calling, texting, writing, anything from the jail. It also includes that. And no contact through social media if you are released from jail. And no contact through third parties with SR. Do you understand, sir?
Yes.
All right, Mr. Sanders, do you wish to be heard?
Yes, Judge. He's lived here all of his life. He has a fiance that he could live with, 2 kids, and he works as part of a labor pool. He can't make the amount the state is suggesting, and he's asking for $500 on count 1 and $500 on count 2. His housing situation is tentative, and his spouse just had to pay the light bill, and he's about to be kicked out. So, taking that in mind, I'm asking that the bond be reduced, and knowing that he probably will be able to resolve the traffic offenses to lower those at another time.
Is his address 3025, looks like Northwest 8th Road?
Yes.
That's your correct mailing address?
Yes.
All right, State, anything further?
One moment, Your Honor.
I'm also gonna order no firearms, ammunition, or weapons, and he's to immediately surrender any, if he does possess any, to his local police department immediately upon his release, okay?
Your Honor, just so the court's aware, on my records, it also shows that the alleged victim resides at that residence as well.
Okay, well, he can't return there.
No, I know, I'm just letting the court know.
Okay, so give me another mailing address, Mr. Saunders.
Okay.
I mean, if he doesn't have an address now, your office can supplement it, or somehow they can get it to him, but it's gonna be his responsibility. But if you want me to have the clerk update it, if he does know an address, I don't mind putting it down.
Not this time, Judge. He's going to explore.
Okay,
Your Honor, just to avoid any potential confusion at a later date, the no contact orders you issued applies to both the felony case and the misdemeanor domestic violence
no,
case?
yes, to
Okay.
the felony and the misdemeanor case.
Thank you.
All right, so this is what the court's gonna do. The court's gonna set bond at $500 on count 1, 1,000 on count 2. The capias is 3, 4, and 5. The court's gonna leave in place. Thank you very
Thank you,
much,
Judge.
sir. Good luck to you. Okay, next case we have is Harlem Garnier, please. Okay, are you Mr. Garnier, sir? Need the victim's initials, please.
They can get.
Mr. Garnier, you are charged with 1 count, aggravated battery with a deadly weapon, domestic violence. Count 2, touch or strike battery with dating violence, $1,000 bond. Count 3 is burglary of an occupied dwelling unarmed. We need to talk about bond. And count 4 is the same thing, touch or strike battery, domestic violence. State, do you have the alleged victim's initials?
I do, Your Honor, and it is the same alleged victim in both cases, TB.
TB?
Yes, ma'am.
Tango Bravo?
Yes, ma'am.
Okay. All right, sir, the court does find probable cause. The court's gonna order no victim contact, direct or indirect, with the alleged victim with the initials TB. That means no contact in person, calling, texting, social media, nothing from the jail, obviously, no phone calls, no writing, no visits, and no contact through third parties. Do you understand, sir? Does he understand, Mr. Sanders? No victim contact, please.
He understands.
Okay, thank you. All right, and court's gonna also order him not to possess, no possession of any firearms, ammunition, or weapons. And of course, he's to surrender any immediately upon his release if he possesses any to his local police department, and he's to maintain 1 mile from the alleged victim at all times. Or I should say 1 mile from the alleged victim's home, work, and school, if any. Okay, State?
Your Honor, based on the totality of the allegations, that both cases involve the same alleged victim, I'm going to be requesting a $25,000 bond on the aggravated battery.
That's count
One.
one,
Yes,
okay.
ma'am. The burglary of an occupied dwelling, I'm going to be requesting a $25,000 bond. And on the domestic violence battery, charge 4, a $5,000 bond, and request pretrial release with a GPS monitor.
Okay, Mr. Sanders, please, your response.
He's lived in South Florida for 10 years. He's worked landscaping, but not full-time. He can't make the bond that's being offered or requested by the state. We're asking that you set count 1 at $1,500, count 3 at $2,000, and count 4 at $500. Taking in light the state's requesting pretrial, that could ameliorate any safety concerns for the community, and the disparity between the bond is not going to make a difference as regard to safety. It's merely a surety for presence at trial.
Okay. Anything else?
No, Judge.
Okay. All right, no victim contact with TB, direct or indirect, no possession of any firearms, maintain 1 mile from TB's home, work, or school, if any, GPS level 2. Court is going to set bond on count 1 at $15,000. Count 2, I'm sorry, is $1,000. Count 3, the court's going to set at $15,000. And count 4, the court's going to set at $1,000. Thank you, sir. Good luck to you. Franklin Terrell Hall, please.
Your Honor, you didn't order a pretrial GPS on that case?
Yeah, I'm sorry, GPS level 2. Mr. Saunders, tell him GPS level 2. Sorry.
He's gone, whatever.
Okay, thank you. Franklin Hall, please. Okay, Mr. Hall, you're charged with domestic battery by strangulation, dating relationship, and then we have count 2, touch or strike battery, domestic violence. The court is going to find probable cause. The court's going to order no victim contact, direct or indirect. You've heard me tell other people that means no contact, sir. In person, calling, texting, anything from the jail in writing. No contact through third parties and nothing on social media. With the alleged victim with the initials TTT, you are not to possess any firearms, ammunition, or weapons. And as you heard me tell other people, if you do possess any, you're to surrender them immediately to your local law enforcement. The court is also going to request that you maintain 1 mile from the alleged victim's homework and school, sir. And State?
Your Honor, I'm going to be requesting a $25,000 bond based on the allegations. Obviously, $5,000 on, $20,000 on 1, $5,000 on 2.
Okay, defense?
Judge, he's lived here his entire life, so he's not a flight risk. He has 1 kid. He resides with his mother in Tamarack. He's worked part-time, worked full-time, but saying that he can't make $25,000. Asking that you set it at $2,000 count 1 and $1,000 for count 2, but adding a 0 to $2,500 is going to be way beyond his reach. He says he'll lose everything if he can't get out, and he's not going to be able to make $25,000 bond on count 1.
Okay, court's going to set bond. Okay, 15,000 on 1, 1,000 on 2, GPS level 2. Thank you. He can go, that's without prejudice, obviously, you can go before Judge Cohen. Debbie Maldonado Retreat, please. Okay, Debbie Maldonado Retreat, please.
Good morning.
Good morning, ma'am. You're charged with trespass, occupied structure, or conveyance. The court does find probable cause. The court is going to order that you do not return to Publix located at 1740 Polk Street, Hollywood, Florida, 33020.
Yes, ma'am.
Okay, hold on, ma'am. Bond set at $100. Can you make that bond, ma'am?
No, not right now. No, I can't.
Okay, does she want to resolve her case? You want to resolve your case today, ma'am?
Yes, yes, ma'am.
Case state, adjudication time served, no return?
Yes, ma'am.
Hold on.
Adjudication time served, no return, Your Honor.
Thank you. Okay, ma'am, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, yes, yes.
All right, you understand
Yes,
I
ma'am.
have to impose, okay, your name is Debbie Maldonado Retriege, Retreage.
Yes, ma'am.
All right, put your hand down. It's my understanding you wish to waive your right to a trial, ma'am?
Yes, yes.
Is anybody forcing you to do this?
No,
Are you under the influence of any alcohol, drugs, or medication?
no,
Ever been treated for a mental illness?
no.
You understand that if you plea here today, I'm going to have to impose court costs of $293, but that I can give you up to 1 year to pay?
Yes.
All right, how much time would you need to pay? 1 year?
Yes, that would be perfect.
Okay, and you understand that if you don't pay it, your driver's license will be suspended, or it could be, probably will be, and that you'll have the $293 on your credit report. You understand?
Yes,
That's not including any collection efforts the state may seek against you. Do you understand?
yes,
Okay, keeping that in mind, you want to plead no contest to trespass, occupied structure, or conveyance?
yes, Your Honor.
All right, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. The court's going to adjudicate your time, serve you, impose $293, give you 1 year to pay. No return to Publix, ma'am, at the Polk Street. Do you understand?
Yes.
All right, thank you very much. Court's going to take a brief Okay, we have to wait a moment to return. We're waiting for a couple people, but I will tell you that the next case is going to be Unique Quince and then Ebony McLemore. Is there a Unique Quince? Pardon? Are you Unique Quince?
Yes.
All right, we just have to wait for somebody for one moment. You know, this is odd. It says, Eric,
Yes, ma'am?
on mine, 7 and 8, KPS felony, and then on the KPS change of charge, it says charge 2 and 3.
I think the
I
only,
don't know why it always changes with that.
it's, yeah, it's,
Do you know why it does that, Ms. Jackson? Like on the KPS, it says 2 and 3, but on the cover sheet, it says 7 and 8.
the KPS goes by the information, the booking sheet goes by how they're booked into the jail.
All right. While we're waiting, ma'am, I can tell you, you are going to go before your division judge, Judge Ernest Kalra, on April 3rd, which is this Tuesday at 8:30 a.m. on these two cases.
Okay.
All right?
Yes.
Huh? Hi. That's all right. All right, Unique Quince, I told her she has two, this is a change of charge.
Oh, it's unique.
It's attempted burglary of a conveyance, two of them. She has, I gave her court date, 4/3/2018. All right, so State, what are you requesting on bond for 7 and 8, or 2 and 3?
Your Honor, you originally, we're just here, I think we're just here, yeah, on these two counts. You originally set a bond on the top count in ROR, the rest of the counts, which include, bless you, which includes these two counts, ROR to pretrial, so we're just asking for the same ROR to pretrial, and the same, any conditions the court previously ordered at the original first appearance are still in place.
Is that regular standard pretrial or GPS?
I believe it was standard pretrial, but I can check.
Not mistaken, I think she does have a private attorney on this case. Is that correct?
Yes.
What was his name again?
Okay, when anybody steps up, if you have a private attorney, you need to let me know, okay? Thank you.
Yes. Sorry.
Who's your private attorney?
Sims Gershon.
Does anybody have his number handy? You want a cup, Julie? Okay.
I'll see if he has a problem with the court ROR and a pretrial on these two counts. I suspect he won't.
I don't think you will either.
And it is standard.
Judge, I can call and let
I
you
got
know.
it.
Okay.
Hello, how are you? Fine, thanks. Okay, you know what we're gonna do? Have a seat, ma'am. We're gonna call another case in the meantime. As soon as we get in touch with your attorney, we'll get back to you, okay?
Okay.
thank you. All right, Ebony Taylor McLemore, please. Okay, Ms. McLemore, you have a KPS ad charge for using unlawful use of false name or identity, bond set at $100. You do have a court date in Division FE, which is Judge Edward Merrigan. It said she had it yesterday. So I don't know when it's gonna be. Everybody's smiling over there. Okay, hi. Does anybody want to be heard with regard to the $100 bond? Okay, can you make a note of this case, Ms. Chase, since she had a hearing yesterday?
I will report on the 3rd.
On April 3rd? Did you go yesterday?
Yeah, I did.
Is that, which judge was that, Merrigan?
Yes.
A male judge?
Yeah.
Okay, and he's gonna reset you for April 3rd? Or 2nd, you said? 3rd? You said April 3rd? It is?
Yes.
All right, April 3rd it is. Thank you, ma'am. We'll keep the bond at 100.
Okay.
All right, have a seat. Holly Michelle Mannheimer, please.
North Road, Your Honor.
Okay, good morning, ma'am. You have one count of battery on an officer firefighter. You need to talk about bond. Count 2 is disorderly conduct, breach of the peace, $25 bond. Count 3, we need to talk about bond, corruption by threat, public servant or family. And count 4, you do have a probation violation or community control, which are going to be held no bond. You do have a hearing on April 3rd, ma'am, which is this Tuesday.
Okay.
In front of Judge William Howery at 8:30 a.m. The court does find probable cause. Hold on, ma'am, we have an attorney representing you here today, okay, in the courtroom with me, Ms. Chase. So, State, let's talk about bond.
Your Honor, in light of the no bond probation hold, I'm going to be requesting $1,500 on one,
Yeah, I'll take a look at it.
$2,500 on three.
I don't remember off the top of my head.
Okay,
Alright,
Ms.
thanks.
Chase?
I can't afford that.
Hold on, ma'am. Okay, 1,500 on one, 2,500 on three, 25 on two. She has a no bond hold. Ms. Chase?
Yes, I noticed, Judge, thank you.
Okay. Okay, so this is what the court's gonna do, ma'am. $1,499 on one, $2,499 on two. I'm sorry, on three, $25 on count two. Let me make it $24 on count two. And that's without prejudice, ma'am, for you to go before your division judge. You do have a no bond hold to talk about the bonds, okay? Thank you.
So that's it.
That's it, ma'am. That's what I'm setting the bonds at today, but you have a no
I
bond hold.
can't afford that. I live off of Social Security. I get $1,000 a month. I can't afford that at all.
All right, Ms. Chase,
I have
without
kids.
prejudice,
I have
you
a
might want to
job.
explain it to her.
I can call over there.
All right, so ma'am, the attorney in the courtroom who's representing you, go to the phone to the left. We're gonna explain it to you, okay? Okay, Kimberly Elizabeth Hanson, please. Kimberly Elizabeth Hanson.
She's coming, Your Honor. She's approaching.
Okay, where are we? North Broward or?
North Broward.
Okay.
North Broward, yeah.
All right, thank you. All right, are you Kimberly Elizabeth Hanson, ma'am?
Yes, ma'am.
All right, you're charged with grand theft between $300 and $5,000, $1,000 bond. Count 2 is dealing in stolen property, $3,500 bond. Count 3 is false owner info pawned items, $300 or more, $3,500 bond. The court is going to find probable cause. The court's going to order no victim contact, direct or indirect, with the alleged victim with the initials LF. That means no contact, ma'am, in person, calling, texting, anything through social media, or third parties with LF. Do you understand?
Yes, ma'am, I have a question. I
Don't
have to
talk
move
about
my.
the facts of your case, though.
Okay, it's just about, I'm a roommate, so what do I have my father get my stuff out of there there then? How do I, if I'm not allowed to have any contact? My bed is in there, my car is there, all my clothes,
Okay,
everything.
State, do you have any objection to, a third party going to the residence with law enforcement?
Oh, with law enforcement, absolutely not.
Okay, a third party is allowed to go back with law enforcement to retrieve your personal items, okay?
Yes, ma'am.
All right, anybody wish to be heard? It's 8,500 in bond. I'm sorry, 8,000 in bond.
Judge-
1,035.35.
Judge, I was going to request a reduction or maybe even a pretrial standard. She's been in Broward County for 29 years. She does have family local. She has a son local that's staying with her ex-father-in-law. The son is 10 years old. She provides some support when possible. She was employed doing dog grooming. However, at this time she's unemployed with no income, no money in the bank. Her parents potentially could bond her out, but they live out of state at this time. She would be able to live with other people locally, obviously not the location where this supposedly took place. But at this point, because she has no money or income, she's not going to be able to post that.
All right, let me ask you this. Where is she going to live? Because right now I have her mailing address is 730 Lock Road, number 74. I guess it's a lot number.
She did. I'm
Hold
sorry.
on one moment.
She did have another address. If she can tell you what that is.
Okay, why don't you tell me about the updated mailing address, ma'am, for you?
908 Republic Court, Deerfield Beach, Florida.
Hold on.
Okay, sorry.
I'm just writing this down, so hold on.
No problem.
Zip code?
33442.
Okay, is there any apartment number with that, ma'am?
It's 908.
So it's 908 Republic Court.
Yeah, and then
Okay.
on the door it says 908.
Okay.
Judge, too, I don't believe she's had any recent priors, and I think mostly misdemeanor history.
State, any objection?
I don't have an objection to pretrial, Your Honor, as long as there's no contact order.
Okay, no victim contact, direct or indirect. Third party can go, such as your dad, with law enforcement to retrieve your personal items
Okay.
at the victim's residence. Standard pretrial release. Ms. Chase, you might want to advise your client. She has to appear if she gets out today. She has to go there by today or tomorrow, okay? Or with 24 hours of release.
Thank you.
You're welcome. You want to call her on the phone quick? North Broward Deputy, can you give this lady a map to pretrial services? I think there's one right there. Thank you.
I will.
Thank you.
Thank you. Okay, Chantal Pearl Pokorny.
She's coming there now, Your Honor.
Okay, where is she? Hello, ma'am. How are you?
Fine, how are you, ma'am?
Fine. Are you Chantal Pearl Pokorny?
Yes, ma'am.
All right, ma'am. You have one count of possession of cocaine, $1,000 bond. Count 2 is drug paraphernalia, possess or use. It's basically an ROR. You do have a probation violation, which is a no bond hold. On counts 3 and 4, you are going before your division judge, Judge William Howry, on April 3rd, which is this Tuesday at 8:30 a.m.
This 8:30 a.m.
Yes, yes. Okay, so the court does find probable cause. The court's going to set your bond, count 1 at $999, ma'am. That's without prejudice for you to go before your division judge if you get a bond on counts 3 and 4, okay?
What do you mean, like 900 and?
I set your bond on the possession of cocaine at $999. You have 2 no bond holds. If your bond changes with the violations of probation, if your circumstances change, you can always go before the division judge and talk to them about your bond on the possession of cocaine, okay?
Okay,
Thank you. Okay, there you go, Steve. Okay, next person is Laura Marie Ballinger, please. Laura Marie Ballinger. Someone tell me where she is? Me?
Bonded judgment.
Oh, thank you, Mr. Sanders.
They might notice that the checks fundraiser are gone.
Rashana Adrienne Durosier, Durosier.
Yes.
Can you tell me where you are, sir? North Broward, Conti, Paul Ryan.
Part right.
Okay. All right, ma'am, you are charged with possession of cannabis over 20 grams, $1,000 bond. Count 2 is possession of THC. The court does find probable cause. Anybody want to be heard with regard to the $2,000 bond?
Judge, I do. I spoke to Ms. Durosier. She is a lifelong resident of Broward County. No significant, I don't believe any priors actually at all. As a high school student living with her mom at this time, has no financial income or money in the bank.
Okay, so what are you asking for?
Judge, I'm asking for ROR.
State, any objection? Nope. All right, ma'am, this is what I'm going to do. I'm going to ROR you, but you must come to court. If you don't, you're going to get a warrant issued for your arrest. You understand?
Yes.
All right. Is your address 754 Southwest 54th Ave, Margate?
Yes.
All right, make sure you look for your notice in the mail. Good luck to you, ma'am. You're going to be released today, okay?
Thank
Heriberto Reyes, please.
Approaching, Your Honor.
Tell me where you are.
North Broward, ma'am.
Thank you. Okay, are you Mr. Heriberto Reyes, please?
Yes, ma'am.
All right, sir, you have add charges, counts 5, 6, and 7, possession of cannabis, 20 grams or less, $500 bond. Next one is possession of drug paraphernalia, $500 bond. And then you have operating without a valid license, $500 bond.
You need to listen, or not me, I'm
All
not the
right,
judge.
so you are going before your division judge, which is Division FJ, which is Judge Diaz, on April 5th, which is this coming a week from today, sir, at 11 a.m.
Yes,
So,
I have an offer if you want.
sure.
Your Honor, the state's offer would be a withholding court cost on the possession of cannabis charge, adjudication time served, excuse me, on the drug paraphernalia and the operating without a valid DL.
Okay, sir, what the state is offering you to resolve your cases today, I don't know what you have for 1, 2, 3, and 4. Does anybody know? He was put on probation. Right.
Oh, no, I think he was placed on probation while he's been in custody, so this obviously
Okay,
was,
so it's not gonna be an issue.
no.
All right, hold on one moment.
Yesterday I was placed on probation, ma'am.
Hold on, sir. All right, at Paul Ryan, we need the deputy. Paul Ryan. Deputy. We can hear, I don't know if it's you that we hear talking.
It's us.
Who is it?
No, it's North Broward, Your Honor. We have the female
Okay.
is upset.
All right, thank you. All right, so, sir, do you want to
Yes, ma'am.
resolve your case today? They want to give you a withhold of adjudication on the possession of cannabis and court costs, and that's so they don't suspend your license. And then, I didn't see you there, Mr. Odom, by the way. Okay, and then on count 6 and 7, the possession of drug paraphernalia and operating without a valid license, the court will adjudicate you and time serve you. The court will impose court costs of $308, and I could give you up to 1 year to pay that. Is that something you'd like to do, sir, or would you like to go to court?
May I ask what's the withhold?
The withhold is on the possession of cannabis. That means no adjudication, no conviction.
Okay, ma'am, y'all do that?
And that's just on the possession of cannabis, but on the possession of drug paraphernalia and operating without a valid DL, the court would adjudicate you and time serve you. Okay?
Yes, ma'am.
All right.
Yes, ma'am.
So raise your right hand, sir, please. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Heriberto Reyes, R-E-Y-E-S.
Yes, ma'am.
My understanding, sir, that you wish to waive your right to a trial?
Yes, ma'am.
Is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any drugs or alcohol?
No, ma'am.
Are you on any medication?
No, ma'am.
Ever been treated for a mental illness, sir?
No, ma'am.
Okay, you want to plead guilty, no contest, or not guilty to...
No contest.
Hold on, let me finish. To possession of cannabis under 20 grams, possession of drug paraphernalia, and operating without a valid DL.
No contest.
Okay, the court is going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court is going to withhold adjudication on the possession of marijuana, which is count 5, and impose court costs of $308. And how much time do you need to pay, sir? I can give you up to 1 year.
Take the year, yeah.
Okay, sir, just to let you know, you can make full payments, partial payments for the $308, but if you don't pay it, know that within the 1 year time frame, you can go to the browardclerk.org, that if you don't pay it, they'll suspend your driver's license, do collection efforts, and it goes on from there, okay?
Yes, ma'am.
So just make sure you pay it. The other thing is, for possession of drug paraphernalia and operating without a valid license, the court's going to adjudicate you and time serve you on each of those counts. The court is going to take judicial notice of the time that you served in the Broward County Jail on count 5, which is the possession of marijuana, since I gave you a withhold of adjudication. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, sir, except for paying your $308. Okay, sir? Good luck to you.
Thank you, ma'am.
You're welcome. All right, Mr. Odom, let's go to North Broward. Good morning. Joseph Curtis, please.
Mr. Curtis.
This one, Mr.
Page 14 of the court's docket. I believe he's at North
Broward. Yeah, this would be adjudication 5 days.
Judge, I guess I'll wait till he gets here before I.
Okay, North Broward, do we have Joseph Curtis? I think a deputy's probably not available over there.
It's very busy today, I see.
He is a medical recent, ma'am.
He is?
Yes.
All right.
I'll save my commentary for another day.
Okay.
And I think the next one, I'm sorry, Judge, is going to be Mr. Metzler, I believe. Peter Metzler on page 12 of the docket. He should also be at North Broward.
Okay, can we have a Peter Metzler, please?
He's approaching, ma'am.
Thank you.
Stand on the edge.
Hello, Mr. Metzler. How are you today?
I'm good, thank you.
All right, sir, you're being charged with 3 municipal ordinances. One of them is shoplifting. The other one is criminal mischief. The other one is resisting arrest without violence. The court does find probable cause.
Judge George Odom, on behalf of Ms. McLaurin, due to the fact that I know the court could always order and reserve, but there's apparently maybe some alleged restitution that's needed in this case, as well as some other issues that I quite frankly have with it. The ultimate decision, if the court is willing to get involved, is up to Mr. Metzler, but what I would ask the court to do is, if the court's not inclined to get involved, or Mr. Metzler does not want to resolve today, he does appear to have a valid address here, local address, and
Is that 3101 Southwest 12th Place?
that's what's on the probable cause affidavit. Mr. Metzler, my name is George Odom. How you doing this morning?
Good, sir, thank you.
I'd like to just put him on standard pretrial if he doesn't, since there's the restitution so high in this case.
And if I can, just for my own clarity, that's the standard in this kind of, I guess, to your staff, the standard pretrial, does that still require a landline? the standard pretrial.
No, he just shows up. He has to
Okay.
report within 24 hours of being released.
Okay.
And he has to call in twice a week. If he doesn't have a phone, he can go downstairs. They have a phone downstairs. But he has to call in twice a week and report once a month until his case is resolved.
So I would ask the court to consider an ROR with the special conditions of standard pretrial release with the conditions that clearly that pretrial has through their policies and procedures.
All right, sir, so the court's going to put you on standard pretrial release. They close at 4 o'clock, but you have to get there by 3. So they'll give you a map right there. If you look underneath, there should be a map to pretrial services. Deputy at North Broward, can we give him a map? Sir, Mr. Metzler.
Yeah, I'm sorry. Your Honor.
Look down is there a shelf there with paperwork?
Down to my right.
Yeah, right in front of you.
Yeah.
All right, take the piece of paper out. Does that say pretrial services? It's a map.
Yeah.
All
Yes,
right,
Your
so
Honor.
take that with you. Court's gonna ROR you, but put you on standard pretrial release. Okay? And you have to show up within 24 hours of being released. You're gonna have to call in twice a week and report once a month. So go there for your initial visit. If you don't show up within 24 hours of being released, you're gonna have a warrant issued for your arrest. I'm gonna ROR you on count 3, counts 1 and 2. I don't need to set a bond. No return service Sunshine gas station. Do you understand?
Definitely, Your Honor. Thank you.
All right, and if you change your address, it's your responsibility, sir, to notify the clerk of court immediately in writing. Okay?
Okay, thank you, Your Honor.
Thank
Judge,
you.
if you to brief me, allow Mr. Metzler, and just for a little bit of more specificity, that means if you're released, if it takes the jail after 4:30 to release you, then the first place you need to go tomorrow morning is on that address on that piece of paper. You understand?
Take that with you, sir, okay?
Yeah.
Okay,
Thank you, Judge.
thank you.
Thank you.
All right, Brandon Matthew Moss. Brandon Matthew Moss, please. Does anybody know where he is?
We're at Maine, Judge.
Okay, thank you. All right, you're Mr. Brandon Matthew Moss. You have count 4, petty theft.
No, I'm sorry. This is what page?
I have no idea. This is Brandon Moss, page 10. Huh?
Okay.
10, thank you. All right, you there? Are you Mr. Moss?
Yes, ma'am.
All right, we're all good now. All right, you have a capious misdemeanor, sir, for a petty theft. It's an ad charge. Bond is set at $250. You do have a court date on April 9th in front of Judge Lerner Wren at 2 p.m., sir, in Division MT. If anybody's curious. Do you want to resolve today, or what are we doing?
Yes, please. Yes, please.
State, can we see if we can resolve the petty theft today for Mr. Moss?
Yes, please.
Judge, what's counts 1, 2, and 3?
I don't know. What? All right, he does have, it appears to me, maybe I'm wrong, he has a burglary of an occupied structure, aggravated assault with a deadly weapon, but then it says count 3 battery.
Your Honor heard his case yesterday. You found no PC for the battery on the ag assault and the burglary. You set $1,000 bonds on each pretrial with GPS.
I would advise not to resolve it because it could be the underlying theft or the burglary.
All right, so this is what I'm gonna do.
The two cases have one, nothing.
Okay, he's saying the petty theft is a totally separate offense and a misdemeanor court, so.
Yes, ma'am.
All right, so I'll just have to keep on $249, okay? Thank
Judge
you.
wishes to resolve because he's saying it's not attached to the felonies or anything like that. He wishes
Can we
to go ahead and
resolve it? I'm sorry, I didn't understand.
The state's offer as of February 14th was adjudication court cost 15 days Broward County Jail based on his criminal
Why
history.
15 days?
Because of his criminal history, Judge. His criminal history is,
Pull up this case, let me see the 173737.
Judge, he was over 15 days the first time he was arrested, he says.
How many days has he been in on this charge? He just was served with it, or does anybody know originally?
Plenty of them.
Maybe you can tell me, Miss Sheila? Sorry. On Moss, can you tell me on this petty theft how many days he has in approximately? That initially.
he's talking about the total amount of time he's had. And Your Honor, I can tell you, okay, 1 moment.
Hello, how are you? Good. Hello. Good. Is trouble brewing? Okay. Okay.
He's got about 7 or 8 days because he was originally given an NTA. He was arrested December 28th on a capias on this offense and was ROR'd and released January 4th. So whatever time he accumulated from his arrest on the 28th to January 4th.
It's about 9 days. 28, 29, 30, 31, that's 4 days. And then 1, 2, 3, 4, that's 8 days.
Technically, under calculation, you're not supposed to count the 28th, but it's either
Okay,
8 or
so
7.
7 days. That was for the first time. And then now is the 26, 27, 28, 29.
Those wouldn't count. He wasn't the cape.
Judge, just so you know that good and gain time, they automatically take off a third of the sentence, so we're just splitting hairs over a day or two.
All right, great. So 15 days, Broward County Jail with credit for time served. Is that what he wants to do?
15 days?
Yes, please.
Okay, and you're sure that this not going to affect his felony cases, right, Mr. Sanders?
Well, it could add a .2 to his felony, but that's okay. Okay. He's fine with that.
All right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, is your name Brandon Matthew Moss, M-A-A-S?
Yes, ma'am.
All right, put your hand down. It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
I'm not.
Ever been treated for a mental illness?
I haven't.
You understand that if you're not a U.S. citizen, a plea of his charge could result in deportation proceedings and affect your ability to remain in the United States?
I do
Okay, you've
understand.
spoken to your attorney that if you get a third theft charge, sir, that they could file it as a felony?
Yes, ma'am.
And you've had ample time to talk to Mr. Sanders?
Yes, ma'am.
And you understand that this could adversely affect you in your felony case by adding some points to your sentencing by pleading to this charge today?
Yes, ma'am.
Understanding what I just explained to you, are you pleading guilty, not guilty, or no contest to petty theft between $100 and $300?
No contest.
Okay, the court's going to accept your plea, find that it's freely and voluntarily given. The court has reviewed the court file, finds probable cause for the plea. The court's going to adjudicate you, sentence you to 15 days, Broward County Jail, with credit for time served. The court's going to impose 200 and, what is it, 293? Ms. Jackson, petty theft, 293. 293 in court costs, time to pay. Ms. Sanders,
Yes.
time to pay, 293.
Year, please.
Okay, 1 year, sir, to pay the $293. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. Okay, you're done with this case, sir, except for paying your court costs.
Thank you very much.
You're welcome. All right, we're going to go off for 1 moment. Michael Stevens. You might, what's his date of birth? You might want to talk to Willie over here.
Okay.
Willie, let's make sure Michael Stevens comes over. He was in Judge who?
Judge Lynch this morning.
Okay, he was in Judge Lynch. Okay, all right. We'll make sure we have it for you, okay? All right, thank you. Jose Feliciano, please. Hello, sir, how are you? All right, thanks for your patience. All right, sir, you have failure to register a vehicle, suspended driver's license. Court does find probable cause. You do have a hearing April 4th in Division MS, which I don't know which is the judge that's handling it, but that is next Wednesday. Bond set at $100 for each count. Mr. Saunders?
Yes, Judge.
Does he want to resolve these?
Yes, Judge. I did reinstate my license. I don't have to call.
Does he have it? Can he get his license?
He says he has his license now. I did reinstate it. I missed the court date to show the license, and that's why the license got suspended again and the charges got reinstated.
Okay.
I don't have
Do we
that
have his
vehicle
driving
anymore.
record? It is?
I assume you just heard what I said.
State, can we find out if can you look it up and see if Mr. Feliciano has a valid DL? Maybe we can do something with, his suspended driver's license.
Well, what I would agree to is, assuming it is reinstated, I wouldn't have an objection to an ROR, so the assigned prosecutor can make a determination how to proceed.
All right, this is what I'm gonna do.
Well, if I could confirm.
Well, he might be able to dump the charge, so why would he want to, I'm saying, unless he wants to admit to it, maybe.
No, what I'm saying is, what I said was, once I confirm, I haven't confirmed yet that it is reinstated. Now, there's a failure to appear, effective date January 29th of this year, and his license is suspended for that. Also, school, something having to do with, I guess,
How can it be added to record on January 1st?
he was given notice, based on his failure to appear on January 9th, that his license was going to be suspended if it wasn't corrected. And then the effective date of the suspension was January 29th. He had
Can we enter an order to lift the D6 so that he can?
Your Honor, we're just here for the capias. He also had, he's also been suspended indefinitely from December 26th of 2017, having to deal with the failure, some type of school attendance issue. I imagine that might be compulsory school.
All right, sir, what's your address?
I'm homeless right now.
Does he have a valid DL? No, because he has a D6. Do you have a mailing address?
No, ma'am.
Really? What is he charged with?
I know what he's charged with.
Hold on, they're talking about something else, Austin. Give me a moment.
Armed
I apologize.
armed burglary of a conveyance with battery, attempted armed kidnapping.
All right, so then they'll have to wait for tomorrow. Okay, can someone call Mr. House and tell him? All right, so this is what the court's gonna do, Austin.
Yes, Judge.
Court is gonna ROR him and put him on standard pretrial release. He can't miss court again. I mean, sir, you have to go to the public library. If I see you here again, I'm not giving you standard pretrial. You're gonna have to wait till you can resolve it in the division unless you can bond out. Do you understand?
Yes, ma'am.
All right, good luck to you, sir.
Judge, can we enter a D6 vacated order
So I can get my license.
so that he can actually get his license back? I know Mr. Linder doesn't want that to happen.
It's not, Your Honor, it's not that I don't want that to happen. This is not the appropriate place for the court
So
to.
can we enter an agreed order to cut bureaucracy and help him out? Mr. Linder?
Your Honor, Mr. Sanders is completely free to make a request, as I am completely free to object. I don't need to comment on his choosing to request. He doesn't need to comment on my objection.
When was it D6'd? Was it January or November? January? If another judge D6'd him, I'm not doing it. If I D6'd him, is he gonna get his driver's license? Why does he need a D6 lifted now, Mr. Sanders?
He can't get his driver's license won't be valid unless his D6 is lifted.
I understand.
And the other one has to do with attendance, and he's clearly a grown man now.
Well, he has so many traffic tickets that he failed to pay, and he's homeless, and you're telling me that he can't bond out, so I don't see that it's gonna make a difference, but in any event, when was the D6 issued? January or November, can anybody tell me? Okay, in the
I don't know.
meantime, I am putting him on standard pretrial release, ROR.
Thank you, Judge.
But he does have to show up April 4th at 1:30, Division MS. You want to write that down for him? What day is that, sir? Did you hear what I just said?
April 4th. Believe it's
That's
Wednesday.
this Wednesday.
Yes, ma'am.
If you don't
I
show
love
up,
it.
you're going to be back here again, okay?
I'll be there.
All right, we'll see. Hopefully you will be.
Ask him that's something, Ming.
Who is Gary Foster? It says the defendant may participate. Does everybody agree? Oh, okay. All right.
Judge, tomorrow's Good Friday. Can he have till Monday to report to pretrial if he doesn't
They're
get
not
out
gonna,
before
are you
30?
open tomorrow?
Can he have till Monday to go to pretrial? If he can't get out by 4 o'clock today?
Why can't he go tomorrow?
Oh, I didn't know. Are they open?
Yes, she said.
Okay. Okay, yes.
Thank you.
By tomorrow.
Otherwise, I'm sorry, Mr. Sanders. I didn't understand why you were asking that. But
Okay.
if they weren't, you would be right. All right, this is what the court's gonna do, Mr. Saunders. I can't find out when a D6 is. I'm not gonna lift another judges. ROR, standard pretrial, he's to show up when his next court date is, okay? All right, Ms. Chase, you'd like to address Gary Foster, case number 18-2569, CF10A. Okay, do you have any objection, State?
No,
Is this an agreed order or no objection?
just no objection, Your Honor.
Okay, thank you very much. All right, there you go. All right, next person is going to be Ronald Bruce Snyder, please.
No problem, John.
Okay, we have Mr. Snyder. Good morning, sir. You have a capious misdemeanor for trespass structure conveyance. All right, I am going to, it's a capious misdemeanor. I'm going to leave the bond in place. I am going to transfer this to Judge Wren. Can I have an order, please? Thank you. $500 bond, sir. You'll go before Judge Wren. Good luck to you.
Okay, thank you.
You're welcome, sir.
Oh, and,
Yes?
no, I'll wait till I'm off the phone, Your Honor. But I spoke to Mr.
You
Gershon.
call up on Wren for that last one?
I'll let her Jay know.
Okay. So what were you saying?
I spoke to Mr. Gershon also on Ms. Chance's case.
I forgot which
Unique
one that
Chance
is.
at Unique Chance at Paul Ryan. Quinns.
I forgot. Tell me who that is. Oh, yes. What was that? Okay, do we have her? Oh, okay. All right, so this is what we're going to do. Let's call Unique Quince. Where was she?
Yes.
Paul Ryan?
Yes.
Hello, how are you? All right, so I was going to ROR you, put you on pretrial release, and keep all the same conditions from when you were first here in magistrate court, or last time, on your two attempted burglary of a conveyance. Did you speak to Mr. Gershon?
I did, Your Honor, and I advised him of the situation. He has no objection to this ROR pretrial, same conditions as before, and he's aware of Ms. Quince's case and
Did you hear that, Ms. Quince?
Yes.
All right, ma'am, good luck to you. Your attorney will be in touch.
All right.
Okay, Jacqueline Pierre, please. Improper change of lanes, okay. Jacqueline Pierre?
Yes, ma'am.
Okay, you have improper change of lanes and operating without a valid license. What are we doing with this?
You want to resolve
What's
this?
the offer state?
Yes. Resolve, Judge.
Resolve?
withhold
Yes, Judge.
court costs.
Withhold court costs, $293, time to pay.
$293 a year to pay? Yeah? Okay.
Okay, tell him, Mr. Saunders, if he doesn't pay, what happens if he still wants to
Your
agree to
license
it.
will be suspended if you don't pay and make payments over the course of this year.
Plus collection, credit report. All right, is that what he wants to do? Plea no contest?
No contest.
Raise your right
All right.
hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
Your name is Jacqueline Pierre, Pierre.
Yes, ma'am.
All right, you can put your hand down. It's my understanding you wish to waive your right to a trial.
Yes, ma'am.
No one's forcing you to do this.
No, ma'am.
Are you under the influence of any alcohol or drugs or medication, or ever been
No,
treated
ma'am.
for a mental illness that would affect your ability to understand what's going on here today?
No, ma'am.
Okay, you understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes, ma'am.
All right, the court's gonna, you want to plead no contest to operating without a valid DL?
Yes.
Yes, ma'am.
All right, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to withhold and court costs, take judicial notice of time that he served in the Broward County Jail. Give him 1 year to pay the court costs of $293. The court, even though it's not for magistrate, since it's attached to this, is going to dismiss count 1, the improper change of lanes. Thank you.
Thank you.
Okay, here's Unique Quince. Gregory Hagler, please.
She wishes to resolve as well.
All right, state offer on Hagler, please. You're charged, sir, with trespassing. Just trying to find the location he can't return to. It's the first page. Okay, no return to 1101 Northwest 31st Ave, Pompano. Will he agree to that?
Yes.
Okay, state, you said? Did I?
Time served.
Adjudication time served, 293.
1 year to pay, Judge.
All right. Sir, raise your right hand. Swear and/or affirm to tell the truth?
Yes.
All right. Is your name Gregory Hagler, Hagler?
Yes.
My understanding, you wish to waive your right to a trial, sir?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Under the ever been treated for a mental illness?
No.
Want to plead no contest to trespassing occupied structure at Marathon Truck Stop?
Yes.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. Court is going to adjudicate time served, $293 in court costs, 1 year to pay. No return to the Marathon Truck Stop, 1101 Northwest 31st Street, Pompano Beach, Florida. Thank you, sir. Good luck to you. Okay, Matthew Dorset. This is state. Can we have an offer? This is to operating without a
Dorset
valid
bonded,
DL.
Judge.
He did? Okay, we don't need a plea offer then. Parrish Anthony George, please.
That's a medical reset, Judge. North Broward called earlier.
Thank you for that. Nicholas Riker, please, and then we have Ever Lewis Fabri Hapina. Your name, sir, Nicholas Riker?
Yes, ma'am.
All right, sir, you have a count of petty theft, first degree between $100 and $300. This is a Walmart. What are we doing with this, folks? $100 bond.
Judge, he can't make $100. He lost his job recently. He's asking that he be given standard pretrial or a standard
He doesn't
pretrial.
want to
He's
try
been
to
a resident.
resolve it?
You want to resolve?
Yes, ma'am.
Yes. He does.
It appears that they got their property back, so what do you want to do?
State's offer is 5 days. He has priors.
How many priors does he have?
Prior 1, 2,
Hello.
2 prior petty thefts, a prior burglary dwelling, grand theft, a prior burg dwelling, loitering
What
prowling.
years, like time frame?
Between 2010, 2014.
Okay. Adjudication, 5 days, Broward County Jail. Credit for time served. Oral ROR.
He would. Yeah. I'd
He'd rather ROR, Judge.
Yeah, I don't want to.
All right, let me just verify his address. Is it 19511 Gulfstream Road, Miami?
Yes, ma'am.
That's where you get your mail?
Yes.
All right, sir, there's no return to the Walmart at 7900 West McNabb Road, North Lauderdale. You understand?
Yes, ma'am.
Okay. Keep up with your court date, sir. Good luck to you.
Thank you.
Thank you. Ever Lewis Cabri Hapina, and then Ira Lee Adler. Which case are you here on? What page is that?
Capra, Capena? Oh, I'm sorry.
No, that's okay. We'll take it after this gentleman. Just tell me the page number and we'll look it up. Here you go, Burke.
Page 18.
What's the first name? Michael Burkenshaw, thanks. All right, Mr. Cabri Hapina, you are charged with 1 count, petty theft. First degree between $100 and $300, same thing. This is Walmart. This is his co-defendant, I guess?
Yes, Judge.
All right, State, you have an offer on this?
Its offer to him, to Mr. Cabrera Pena, would be 3 days. In 2017, in Dade, he had a burglary of a structure, grand theft, resisting without violence, criminal
Okay,
mischief.
so adjudication, 3 days with credit for time served. If he doesn't want to resolve, I'll ROR him, he can show back up.
Yes, ROR, Judge.
All right, let me verify his address, 30340 Southwest 170th Ave.
Yes,
All right,
Judge.
make sure he looks at the court date. We're going to take one at a turn. This is page what? Page 18, Michael Francis Burke.
Morning, Your Honor. Ramona Tully on his behalf. Thank you for the phone call. Judge, as to the new offense, I've read the probable cause affidavit. I do not have an argument as to probable cause on the new offense.
All right, so let me just get him up. Are you Michael Francis Burke, sir?
Yes, Judge.
Okay, good morning, sir. We have your private attorney, Ramona Talley, here. You have count 1, false ID given to Leo. The court is going to find probable cause, bond set at 100. But counts 2 and 3 are warrants for VOP pretrial felonies, whereas he's being held no bond. Actually, that's not for magistrate. So, you want me to keep his bond at 100?
Yes, please. And just for the court to know and Mr. Burke to know, there is a hearing in set in front of Judge Michael Lynch on April the 3rd with regard to the pretrial release.
All right, so that's this Tuesday, sir, okay? So the court's actually going to make his bond $99, okay?
Thank you, Judge.
Thank you.
And
Good
thank you
luck
for the
to you,
courtesy
sir.
call.
Thank you, Ramona.
Okay, thank you. All right, Ira Lee Adler, please. Ira Lee Adler. Can someone tell me where he is? Hello, sir, how are you?
Yourself?
Fine, thank you. You're charged with resisting an officer without violence and trespassing an occupied structure. You want to resolve this case?
I was asking if we could maybe ROR him and send this to Veterans Court.
Can I send this to Veterans Court?
I
No,
remind you, there's
I
a
can't.
process to go through.
Okay. Okay.
But this
Which
is a
result?
misdemeanor.
Okay.
They take
Why don't we,
misdemeanor.
huh? Say that, hold on, can you mute that, because I can't hear the clerk, I'm sorry. Judge Merrigan takes misdemeanors, right?
So,
Oh, that's fine. I appreciate that. I didn't know that. All right, so what are we gonna do with this?
he's out on a battery right now that he was ROR'd on.
He's out on a battery. I mean, there's something going on here.
I think he'd benefit if we
It's
could
not
get
an
him
MI,
into.
though. It's a regular division.
You wanna set him to learn a Ren, maybe?
Yeah, I mean, that would be fine too. I don't know if I think Merrigan would be able to link him up with services. He was honorably discharged from the Marine Corps, 6 years, so that's why I was thinking the VA services that they have he's a retired county worker, and he's currently doesn't have a residence, but he has worked for the county for some time and served our country for 6 years in the Marine Corps and with an honorable discharge. And 67 years old.
All right, so, Ms. Jackson, since you were there for the inception, how do we accelerate this so he doesn't sit in jail on 2 misdemeanor charges forever? So, but then he might. State, nothing's been filed yet, obviously. Okay, here you go. Make a copy of that. I'm gonna follow up on this case. I'm gonna leave the bond at 100, okay?
Okay, Judge. Is that going to be reset or reset to the afternoon?
Who, him?
Yes.
No, what I'm gonna do is I'm gonna contact Judge Merrigan's office.
Okay.
All right, and see if we can expedite this because of the nature of the charges and what I read in the PC, all right?
Understood. Thank you.
All right, you're welcome. Did someone call Mr. House and tell him about Michael Stevenson? No response? Did anybody call?
Yeah, I spoke to Mr. Howes about it.
You did? All right, Willie, cancel Michael Stevenson for magistrate court. That was the one that you called up. He was in Judge Lynch. He doesn't, because he called up for them to bring him. Did they tell you they were bringing him? Okay, fine. I'm not that I'm doubting you. All right. All right, so. Make a copy of this? No, this and this. And then you can give that to the clerk. Okay, Nicholas Ashley, register, please. Yes. All right, Michelle, why don't you make an extra copy? Okay. And we can give it to Julie. Make an extra copy of this PC so you can reference it too, okay? All right, thank you. Nicholas Ashley, register, please. Hi, sir. Hi. You have 1 count of drug paraphernalia, sir, $100 bond. Then you have 3 capious misdemeanors, $500 bond, $250. So total of $1,100 bond. You are going before your division judge, Judge Jill Levy, on April 9th, which is a week from this coming Monday at 1:30 p.m. Court does find probable cause. He was a no-show at a hearing. That's why Judge Levy did these bonds of $250, which I'm not going to disturb, and $500. So I don't know if there's a chance of him resolving it today, state or defense?
Yes, we'd like to.
Well, I don't, frankly, based on the allegations, I don't know of an offer at this time. I'd have to.
Let me see the allegations. All right, so the court's not going to resolve it today based on what's in the probable cause affidavit. So.
This is the most recent one, Judge?
Pardon, the most recent one.
Okay.
All right, so bond is set at 100 on count 1. The 500, the 250, and the 250 I'm not disturbing. What do you want to do with regard to the drug paraphernalia? $100 bond. You want to leave it in place, or you want to argue something, Mr. Sanders?
Well, he's not able to make it. Asking just standard pretrial, I guess. He's been here his whole life, 27 years old.
All right,
he's
so
worked
on
in the
count
past.
one, I'll do standard pretrial release, okay?
Thank you, Judge.
You're welcome.
Who's,
ROR. Yep. You're welcome. Keith Ray Fernandez, please. We have an offer in this case. State. Possession of marijuana under 20 grams.
This is drug court.
Oh, it is? Okay.
And posted.
Okay, his bond's been posted. Excellent. Makes it easy. Pardon? Yes. Albert Curtis Eckerd.
Present, Judge.
All
He
right.
wishes to resolve.
State.
State's offer be time served, no return. Oh, let me wait till he gets up there.
Adjudication,
Your
time
Honor,
served, no return.
He was still walking up, Your Honor.
No, I'm telling Mr.
Okay,
Sanders that. I didn't know if he heard you.
Yeah.
But thank you for telling me that.
Time served, you want that?
Time served?
Done with it?
And no return.
No return to that location. You want that?
Where's the location?
He'd like to accept the charges.
700 West Commercial Boulevard.
700 West Commercial Boulevard. Time to pay? 1 year?
Judge, he wishes to plead no contest, Judge.
All right, Mr. Eckerd, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay. Is your name spelled Albert Curtis Eckerd, E-C-K-A-R-D-T, sir?
Yes, it is. It's Albert Curtis Eckhart II.
Oh, the second. Okay, I'll make a note of that, sir. It's my understanding you wish to waive your right to a trial?
Pardon me?
You want to give up your right to a trial?
Well, resolve it today?
Yes, I'd like to accept the charges for value.
All right, no one's forcing you to do this?
No one's forcing you, right?
No, ma'am.
You understand what's going on here today?
Well, the trespassing was,
You don't have to worry about it. But you understand that you're giving up the right to a trial and you want to just close the case out now, right?
yeah, I'd like to close it out.
Okay, court's going to accept his plea of no contest on trespass, failure to leave property upon order by owner. Find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause. Adjudication, time served, $293 in court costs, 1 year to pay, no return, 700 West Commercial Boulevard. Thank you.
Okay, am I allowed to use my bonds?
Yes, thank you. Thank you. John Harold Foltz, please. John Harold Foltz, please.
Thank you, ma'am.
You're welcome.
Foltz bond? Foltz is on 16.
John Harold Foltz, yes. Does anybody know
Medical
where he
reset,
is?
Judge.
Oh, medical reset, okay. John Harold Foltz, Julie. Vincent Quick.
Conti.
All right, and then we have Jovan Spencer. Okay, Mr. Quick, you have an ad charge, a capious felony for aggravated assault with a deadly weapon. You do have, I'm sorry, it's a misdemeanor upgrade in case number 18-1104 MM10A.
Yeah.
So you have an aggravated assault with a deadly weapon. That's the only one. I'm not here on the battery.
Yeah, Your Honor, if I may, it's an ad charge. The reason it says misdemeanor upgrade, he was originally just arrested for battery. So when we ad charged the felony count, it upgraded it from misdemeanor to felony.
Okay. All right, did you hear that, sir?
Yes, ma'am.
Okay. All right, so the court does find probable cause. Let's talk about bond.
Your
What's his
Honor,
bond now?
it's $5,000 on the battery,
Okay,
the domestic violence battery. He has a no bond out-of-county hold out of Hillsborough County for a violation of probation on reckless driving.
okay.
Your Honor, I can tell you the allegation in this case is he allegedly threatened one of the victims with a metal pipe. Your Honor, based on the totality of the circumstances, the allegations in the report, I'm requesting a $5,000 bond on the aggravated assault, no victim contact. And I believe it is a different alleged victim than the battery charge.
Okay, defense?
Has other no bond holds, correct? So, one other, leave it as
Out-of-county.
is. That's fine.
All right, so the court's gonna set the bond at $4,999, no victim contact.
Yes, I request no victim contact with EM.
Okay, no victim contacts are direct or indirect with the alleged victim with the initials EM. That means no calling, texting, no writing letters. That means even while you're in jail or out of jail, sir. No contact through social media or through third parties. Do you understand?
Yes, ma'am.
Okay, you're to maintain 1,000 feet at all times from EM. You are to surrender you're not to possess any firearms, ammunition, or weapon. And if you do, sir, when you're released, you're to immediately surrender them to your local law enforcement. You understand, sir?
Yeah, yes, ma'am.
Okay, and the court is gonna do a GPS level 2 if he is released on this count only. Thank you.
Excuse me.
Yes,
Your
sir.
Honor.
Yes.
As far as EM, the alleged victim, they say that's what I had used a weapon against the weapon. That's what I'm being accused of.
Don't talk about the facts of your case, sir. I'll let Ms. Chase explain that to you, okay?
I'll give
All right, thank you.
I'll give you a copy of the information. I gave you a copy of the report, but it's multiple pages. It might be easier if I just print out the information.
All right, sir, go to the phone on the left. The attorney will call you now. Who do you have? How many people?
Oh, Your Honor, actually, I'm sorry. I apologize. Could he come back? Could you have him come back,
Can we
please?
have him come back? I'm sorry. State wants him back.
And I apologize, Your Honor. I got the charges reversed. The no.
All right,
I'll
let
wait till he
me,
gets back.
is it a different victim?
Yes.
All right, so sir, the state attorney has advised me.
The no contact order should be for BF. I apologize.
Okay, the state attorney advised me that the alleged victim is not EM, it's BF. Okay?
Okay,
Does that resolve?
Yes.
All right, thank you very
Perfect,
much.
thank you.
Good luck to you. All right, who do we have? Deputy at Conti?
From yesterday, Jonathan Tankersley.
Okay, that one we're gonna have to wait till the end because it's really involved.
Okay. All right.
All right?
Thank you.
Thank you. Sorry about that.
No.
Yeah.
All right,
think-
Giovanni
He said-
Spencer,
he said
please.
it's okay, he understands.
Where's
It
Tankers?
was just the confusion over the.
Giovanni Spencer, sir?
Mangel?
Okay, Mr. Spencer, you have an ad charge. Grand theft auto. Bond is set at $1,000. Court does find probable cause. State?
Mr. Spencer has multiple no bond holds. I'm just requesting that the bond be kept in place.
No objection to that, Judge.
Okay, there's no victim contact, direct or indirect, with the alleged victim with the initials RTN. Do you understand, sir? That means no in-person, calling, texting, whether you're in jail or not, social media, and through third parties. You understand?
Yes, ma'am. Yes, ma'am.
All right, court's gonna do your bond at $999. Thank you, sir. Fabian O'Neill Moncrief.
Moncrief, he's approaching. Morning, Your Honor.
Hello, sir. You have some ad charges, count 11, burglary, occupied dwelling, unarmed. We need to talk about bond. You do have grand theft between 20 and 100,000. Bond's been set at $5,000. The court does find probable cause. The court is going to order no victim contact, direct or indirect, with the alleged victims with the name Jack and Christina Bransfield. Do you understand?
I don't even know that. Understand though, right? Yes, ma'am.
Okay, if you do find out who they are, sir, no contact. Not in person, calling, writing, texting, third parties. You understand?
Got you, Your Honor.
Okay, State, what are you requesting on count 11 and 12?
Your Honor, he has a $10,000 bond already on a burglary of an occupied dwelling and a total of $9,000 on multiple other counts involving stolen credit cards, grand theft. I'm asking for the same $10,000 bond on this burglary occupied dwelling, and because of the alleged amount.
Okay, when you say the same, you mean, because I heard you counting and then say 9,000, so you're saying 10,000?
The 10,000 that you originally said on the burg dwelling, he's already being held on. I'm asking for the same bond as in that charge, 10,000. And I'm asking that the court keep the $5,000 bond on place on the grand theft, considering the alleged value of the property stolen is just under $50,000. Oh, and Your Honor, you also put him on pretrial GPS on the other counts. I'm asking that that condition be placed on these counts as well.
Judge, in light of the fact that the state's asking for GPS monitoring, he can't make a monetary bond, and we're asking that you give him pretrial level 2. He was in a car accident recently and is in need of surgery to his neck. He's just doing pain maintenance at this point. He's worked construction in the past. He resides with his mother in Deerfield, so he has ties to the community. And we're asking that no monetary bond be placed on this, and any concern for safety or accountability would be ameliorated by the GPS monitoring and the other bonds that are already in place.
Okay, court's going to set the bond on count 11 of the occupied dwelling at $10,000. Count 12, the court's going grand theft between 20 and 100, is going to keep it at the 5,000. Court's going to put them on GPS level 2. No return to this address on Hillsborough Mile. Thank you. Yarheem Jaron Williams, please.
We have one.
Okay, Mr. Williams, you have 2 ad charges. It is burglar, unlawful possession of personal ID of another, 4 or less. You're going to be ROR'd on that. And then count 3 is burglary of an unoccupied dwelling, unarmed. Court does find probable cause. State.
Your Honor, I'm going to be requesting a $5,000 bond on the burglary dwelling. Your Honor, just noting, you had him in the morning and afternoon yesterday. Originally, it was on a burglary conveyance. You ROR'd him to pretrial to GPS. Then in the afternoon, you ROR'd him on count 2. But obviously, the court wasn't aware that he's also had now has a burglary of a home attached to him.
Yeah, he was in a home.
We're not addressing the facts.
Okay, no victim contact, direct or indirect, with the alleged victim with the initials CE, and no return certainly to his residence. Go ahead.
Judge, he's been residing in South Florida his entire life. He's 21 years old. He has 1 child. He lived with his mother. Currently doesn't have a job or a means to make a monetary bond, understanding that the dwelling elevates it to a 2nd degree. But any concern for safety of the community and accountability, I think, is accounted for in the fact that he's already been ordered to level 2 pretrial with GPS monitoring. He's essentially on house arrest without prior permission. Asking that you not set a bond on this and just release him to pretrial level 2 like the other counts.
Okay, so on 2, it's going to be ROR, but on 3, the burglary of an unoccupied dwelling, court's going to set bond at $7,500, GPS level 2. Thank you. Alex Claude Cadu, looks like C-A-D-E-A-U, I'm not sure.
Yes.
Hi, good morning, sir.
Good morning.
All right, you have count 1.
Judge, do you refuse?
Okay. drug paraphernalia, possess or use, $100 bond. Counts 2 and 3, you have no bond holds. You are going before your division judge, Judge Dennis Bailey, on April 3rd, which is this coming Tuesday at 8:30 a.m. on the 2 no bond holds. We do need to talk about count 4, possession of a weapon or ammo by a convicted Florida felon. Court does find probable cause. State, what are you requesting?
Your Honor, in light of the fact that the allegations are for ammunition and not a firearm, but he is on probation for 2 burg dwellings, I'm asking for a $1,500 bond on count 4.
Okay, sir. This is what the court's going to do. On count 1, $100. Counts 2 and 3, that's set by Judge Tim Bailey. No bond holds. Count 4, $999. You'll see Judge Bailey on Tuesday, okay? Thank you. Have a good day. Yes? Hold on, come back, sir.
We're gonna notify, just to let him know, we're gonna notify probation, because it looks like his probation terminated upon completion.
All right, so you want to tell him that, or have Ms. Patrice tell him? That's why I asked Craig to get a microphone. Maybe we can get one of those regular ones there.
Sir, just looking into your case, it looks like on your probation cases, that you're not on probation, that your probation was terminated when you completed your Broward County Jail system.
I can't even hear her. She's talking to me?
Yes.
I can't hear her.
All right, hold on.
Can you hear me now?
Yeah.
On your probation cases, it looks like when you were here that you served Broward County jail time. When you was released, your probation was terminated at that time, which the officer did not know that. So we're going to notify probation, and if that is the case, those 2 charges will be dismissed off of you, okay?
All right. Or can I get an RR?
Probation will send a dismissal.
Okay, probation's going to send a dismissal, sir. That's what I've been told.
What?
Okay, thank you. Timothy Lewis, please. Okay, Mr. Lewis, you have a KPS felony, KPS misdemeanor. You have a no bond hold because you didn't show up for a jury trial in front of your division judge. I don't know which judge this is.
On count 1?
On the felony.
It says Bober on the booking.
All right, I don't see it. But. All right, sir, in any event, you have a no bond hold on your KPS felony. Actually, it's not even for magistrate. Count 2 is a KPS misdemeanor. Bond's been set at $500. You also have a no-show, a calendar call for criminal mischief with damage under $500. You are going before your division judge, Judge Bob Diaz, on April 5th, which is a week from today at 11 a.m. Thank you, sir. Good luck to you. Ellie Walter Adams, please. Okay, are you Mr. Adams?
Yes, ma'am.
Okay, good morning, sir. You have KPS misdemeanor, $500 bond. Counts 2 and 3 are KPS felonies, they're not for magistrate. Count 4 is a KPS traffic, $500 bond. So he has 2 no bond holds and 2 $500 bonds. He was a no-show at arraignment. Court's going to take on count 1, bond at $499, and count 4, $499. Thank you, sir, and good luck to you. I don't know when your court date is. You have to reach out to the public defender and ask them when your court date is. Thank you. Jordan Monagas, please, and then we have Stefano Arbalaze. Here you go, Ms. Patrice. Jordan Monagas, sir? Is that your name? Okay, hello.
Yes, ma'am.
You have grand theft auto, $1,000 bond, counts 2, 3, 4 and 5 are not for magistrate. They're actually no bond holds. Court does find probable cause. Anybody want to be heard with regard to the $1,000 bond?
We're
Okay.
fine with it.
Okay, $9.99. Thank you. On count 1, grand theft auto. Stefano Arbalaze and Peter Bonbon. Hold on. Stefano Arbalaze. Hello, sir. How are you? You are charged with 1 count of burglary with assault or battery. There's no bond, and count 2, driving while license is suspended. Third or subsequent offense, which you're being charged as a felony on that one, $750 bond. Court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials DJFM. That means no contact, direct or indirect. You probably heard me tell other people, no contact in person, texting, calling, no contact through third parties. You understand?
Yes, ma'am.
All right.
Thank you.
Okay, state.
Your Honor, the state is going to be seeking a no bond hold on count 1 on the punishable by life burglary with assault or battery, seeking a finding of proof evident or presumption grade for first appearance purposes only. Noting, Your Honor, that the allegations as contained in the probable cause affidavit would satisfy the elements of the offense. The arresting officer observed the incident on video surveillance, which corroborates the victim's version of events. Also noting the significant injuries suffered by the alleged victim, and also noting, Your Honor, the victim advised law enforcement that Mr. Arbalaze is personally known to him, enabling him to identify him as the person that committed the offense.
Judge, we would object to a finding of proof evident presumption great and ask the court to set a bond in this case. If the court is inclined to make that finding based on the probable cause, we'd ask the court to exercise discretion in setting a bond.
All right, sir, I've reviewed the probable cause affidavit filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, on count 1, burglary with assault or battery, you're going to be held no bond until further order of the court. This order is without prejudice, sir, for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. Count 2 is going to be set at $699. Thank you. Good luck to you, sir. Peter Bonbon, and then Anthony Leon Stubblefield.
Hello, how are you?
Okay, hello, Mr. Bonbon. You are charged with 1 count use or display a firearm during a felony. We need to talk about bond. Count 2 is possess with intent to sell, manufacture, deliver MDMA. Ecstasy, $2,500 bond. Count 3 is possession of cannabis over 20 grams. $1,000 bond. Court does find probable cause.
Judge, I did have objection as
sure.
probable cause. I'm sorry. I don't see any intent or evidence of intent to deliver these items. Were located in the car in the absence of any other items normally used in terms of intent to deliver. There's no other involvement by any person, no observation of a hand-to-hand by any officer. So I don't see any evidence of the intent to deliver. Also, as to count 1, use or display during a felony, I would object to that as well, as it was apparently in the trunk at some point, discovered by the officer later.
Okay, defense. Hello. No, that's okay. I'm just saying hello. Go ahead.
That's fine, Your Honor. But I would like to address the bond.
Okay, so that's fine means what? No PC on count one?
Yes. And I'm fine with possession on count 2.
So it'd be possession, not possession with intent.
I'm fine with possession.
Can I put simple possession?
Yeah, that's possession, yeah.
Just so we're all clear. Okay, count 3, do you have a probable cause argument?
Judge.
No? Okay. All right, so then, no PC. Okay, so go ahead. So count one's gonna be an ROR. So we only have to talk about the simple possession of MDMA, ecstasy, on count 2, and the possession of cannabis over 20 grams, $1,000.
Your Honor, I'm going to be, even though the court has found probable cause for a lesser offense on count 2, I'm still going to be asking that the standard bonds be kept in place. One, Your Honor, as far as aggravating factors, I direct the court's attention to the last sentence of the probable cause affidavit, and I do have safety concerns, and I can advise the court and confirm that he is registered as such by the Florida Department of Law Enforcement. Additionally, though while not charged with it, I believe it is an aggravating factor that the court can consider. Mr. Bonbon is not lawfully allowed to be in possession of a firearm. He currently has a non-expiring injunction order of protection in Broward County placed against him, and a condition, and I reviewed it on Odyssey this morning, a condition of that injunction by, I believe it was I believe it was originally Judge Kaplan, is that he's not to be in possession of any firearms, weapons, or ammunition.
Judge.
Yes.
He's lived here all of his life. He has 2 kids. He works as a laborer in roofing. He's a victim of being stabbed in the past and has problems with his lungs, as well as seeking possibly getting disability. We're asking that you set the possession on count 2 to be $750 and the cannabis to be $250, taking that in light. I also ask that you disregard everything to do with the argument that we found no probable cause on count 1 to a firearm. Even if there is an active injunction, he still has the right to keep arms in his home. We don't know if that was his, and even knew it was in the car, so all the arguments the state has to do with him not having a gun has nothing to do with the counts that we're here for now that there's not probable cause found.
All right, this is what the court's gonna do. ROR on 1, 750 on 2, 250 on 3, and I am gonna do a GPS open schedule. Thank you.
Judge, there's one other thing.
Sure.
Now that it's been down, I just want to notify pretrial that he'd be eligible for drug court, so if they can screen him for drug court.
Sure.
Thank you.
Thank you. Anthony Leon Stubblefield, please. Are you Mr. Stubblefield? Hello.
Hello, how you doing? I was talking about, I gotta go to bed.
Okay, sir, you have a grand theft, count 1, between $300 and $5,000, $1,000 bond. Count 2, possession of counterfeit bank bill, check, draft, or note, $1,000 bond. And counts 3 and 4 are capious misdemeanors with bonds of $500 on each one. You are gonna have, can't tell, let me see which division it is. It's gonna be set in the future, it's not set right now. I do have victim notifications. Court does find probable cause. You're to have no contact, direct or indirect, with the check cashing and loan store at 1355 North State Road 7, Lauderhill, Florida. 4 with Affinity Resources at 800 West Cypress Creek Road, Suite 430, and additionally, you're not to return to those businesses, okay? Okay, go ahead. Go ahead, Mr.
Judge,
Sanders.
Hello? No, we're waiting for Mr. Linder, right?
No, go ahead. You want him to go?
Okay.
Yeah, that's what I thought you said.
All right, it's $3,000 bond.
Judge, can't currently make a monetary bond. Resigned for 3 years in South Florida. He said he could possibly live with his sister, but he currently is homeless. He does work at Dollar Tree as an associate, but only part-time. Actually has to be to work today at 4 o'clock. And we're asking that he be given standard pretrial on 1 and 2, and allow him standard pretrial on 3 and 4 as well, and possibly send those to misdemeanor drug court.
I'm not doing anything on 3 and 4. He failed to appear and no-showed at arraignment. So the only thing I can tell you is we're going to just address 1 and 2.
Yes, ma'am. Asking for standard pretrial.
State?
Sure.
Sure, ROR, standard pretrial. Explain to him that if he doesn't show up, what happens, because if he comes back, he's going to get violated.
Okay. Do we know when the misdemeanors are set on in division?
It says to be set. I don't know if it's division MB or MS. It came from South County.
MD.
MD, I'm sorry.
Was
Just
there a
have him
transport order
contact-
from?
Huh?
Was there a transport order from Satellite to have it sent to Central?
No,
not,
if
can we
he's
enter
in
one?
custody, oh wait,
So the
is it gonna
clerk will-
stay there?
If he doesn't bond out, the clerk will automatically transfer the.
Okay, but if he does,
If he bonds out, then he'll have to go, it'll get set in South Satellite, he'll have to go.
okay, did you hear that?
Is there any way we can expedite him getting it sent to Central so that you can address it?
How long does it take?
I think we can enter an order, just enter
Okay,
an order.
3 to 5 days.
Is there any way we can just enter an order?
I can't do it. I can't just take this one at a turn and,
I mean, his
they're
livelihood's
working, they're
depending on
working
it,
on it, okay? Have,
Thank you.
contact the public contact your
We don't-
office.
We don't represent him, and he probably doesn't even know how to on those cases
I don't
yet,
have,
so.
Your Honor, I don't have an objection if you want to appoint the public defender and then.
I'll appoint the public defender for you, okay?
Okay.
All right, thank you. No problem.
Okay.
Aliasio Anthony Avenue. Okay, Mr. Avenue, you have count 1, false ID given to Leo, $100 bond. Count 2, 3, 4, and 5 are no bond holds. Counts 2 and 3 are probation violations. And counts 4 and 5 are out-of-county holds felonies, no bond. They're actually not for magistrate. Court does find probable cause, so the only thing we have to deal with is the false ID to Leo, $100. Does anybody care if I set it at $99? He has no bond hold. Mr. Sanders?
I have no objection to that. Is there probable cause found?
Yep. Thank you. Next one is John Rashad Dinkins, please, and Andre Stout, I'm sorry. Okay, are you Mr. Dinkins?
Correct. He has private counsel?
Okay.
Yeah, no, I'm seeking private counsel, correct.
Okay, do you have private counsel yet? Hold on, Mr. Sanders. Do you have private?
No,
You
ma'am.
don't?
I didn't
So
have
for
time
purposes of today, sir, do you want to use Mr. Saunders from
You
the
can
Public
stand in
Defender's
for me.
Office? Okay, excellent, thank you. All right, so the court will appoint Mr. Saunders for today, or the Public Defender, I should say.
I do have, I'm sorry.
Okay, let me just tell him what he's being charged with.
Fine.
Thank you for letting me know, Julie. So, sir, you have 1 count of possession of THC, and count 2 is a capious misdemeanor. Bonds are set at $1,000 and $500. They do have, Ms. Chase does have an objection of probable cause. I'm assuming it's not on the operating on a valid DL.
Correct, it's on count 1. As far as there was no result, the officer states in the probable cause that he tested the substance. However, it doesn't say whether it was negative, positive. There's no result indicating.
It says tested positive.
I'm sorry,
says and tested positive.
Oh, you know what?
It's a light copy.
My
that's what
copy
it
doesn't
is.
have that. It just basically says was tested. So, okay, I see.
Okay. He probably doesn't have the second page.
Ah, that too.
All right, so the court is gonna find probable cause for the possession of THC, $1,000 bond. The, operating without a valid DL, Mr. Saunders, is a defendant no-show capias. It is from Division MT, which is Judge Lerner Wren. So,
Judge,
I don't know if he wants to
I have a
resolve it.
recommendation if we can.
Sure.
I'm asking for him to be ROR'd on the possession of THC because of immigration consequences. And on count 2, I'm asking that he be able to resolve that count.
State?
The offer on the operating without would be an adjudication time served.
He'd like to take time served on the operating valid, no valid DL.
Time to pay?
1 year, Judge.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Affirm.
Okay. Your name is Day, D-E, John, Jon, Rashad, R-A-S-H-A-D, Dinkins, D-I-N-K-I-N-S.
Upper lowercase, yes.
It's yes, R,
Yes, 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 yes.
D-I-N-K-I-N-S, right? Yes.
Yes.
It's my understanding you wish to waive your right to a trial?
That's for the time served?
For the operating no valid driver's license.
That's the time served, correct?
Yes.
Okay, yes.
Is anyone forcing you to do this?
No.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Ever been treated for a mental illness?
No.
You understand that if you're not a U.S. citizen, a plea of his charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes.
Actually, it says that he was born in Fort Lauderdale, but... Okay, you understand that there's going to be court costs imposed of $293?
Yes, I have a job I just missed today because I was here.
Okay, the court will give you 1 year to pay that. So, sir, understanding what I just explained to you, you want to plead guilty, not guilty, or no contest
No contest.
to operating without a valid driver's license?
No contest.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate your time, serve you, impose court costs of $293, give you 1 year to pay. Mr. Saunders will tell you what happens if you don't pay within the 1 year. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. As far as the possession of THC, what are we doing with that?
Asking for ROR, Judge, so that maybe he can seek drug court or seek some kind of defense.
Okay, ROR. Let me just verify his address. Is it 6004 Northwest 1st Street, Margate?
Are you still on?
Correct, I don't miss out there.
All
Correct.
right, if you change your address, sir, you have to notify the clerk of court immediately and your attorney in writing with your case number, all right? Thank you. Good luck to you. Don't miss your court date. Andre Stout, please. Andre Stout. Okay, Mr. Stout, you have trafficking cocaine, 400 grams. Between 400 grams and less than 150 kilograms. The standard bond is $250,000. Count 2 is use, display, etc. firearm during a felony. We need to talk about bonds. Count 3 is grand theft of firearm, $1,000 bond. Count 4 is possess with intent to sell, manufacture, or deliver cannabis, $1,000 bond. And then you have a probation violation. You have a no bond hold. I don't know when your next court date is.
It's out of Brevard County.
Oh, it's out of Brevard County, I'm sorry, sir. So you have a no bond hold on that count. Court does find probable cause. Anybody want to be heard with regard to any of the bonds, and state what are you seeking on to?
Your Honor, I'm gonna ask that the bond on count one be kept at $250,000, $50,000 bond on two. Your Honor, I would note, it doesn't indicate it on the probation violation count. He's actually on probation for 7 different counts of grand theft auto. Your Honor, I'd also note, they found over a kilogram of cocaine, over $1,450 in U.S. currency divided in denominations consistent with street-level narcotic sales. It does 281 grams of cannabis. It does appear that Mr. Stout is significantly involved in drug dealing.
Okay, defense?
Judge, he's resided in South Florida for 6 years. He has 4 kids. He reside with his girlfriend. He'd reside with his mother. He is a U.S. citizen. He, detailed boats for a living, working full-time. He cannot make it $250,000 in light of his kids and his employment, asking that you set count 1 at $25,000 and count 2 at $1,000.
I apologize. One other thing I want to bring to the court's attention.
Okay, if you could talk a little louder.
Yes, one other thing I want to bring to the court's attention. I'm showing in 2015, Mr. Stout was arrested in the Virgin Islands as a fugitive from justice.
Judge, that's from another country, and I don't know how to verify that, or I don't know how to even respond to that, but
Was it the U.S. Virgin Islands?
I'm sure that.
Your Honor, this is on the FBI's database. I believe the court can rely upon that.
All right, anything else, Mr. Sanders?
Not this time, Judge.
All right, this is what the court's gonna do, 250,000 on 1, 25,000 on count 2, 999 on 3, 999 on 4, no bond on 5, on counts 1, 2, 3, and 4. Court's gonna do GPS open schedule. Thank you. Raquan Campbell, please. Raquan Campbell.
Bonded, Judge.
Okay, then we have Christopher Fabian. I think it's Mejia. Is that how you say it, sir? Did I say it right? Okay, thank you. All right, sir, you have 2 capious felonies, are actually not for magistrate, just to let you know. You have 2 no bond holds. And then on count 3, you have a capious misdemeanor for possession of cannabis under 20 grams. You no-showed on March 19, 2018. Was he in custody?
I'm sorry?
Was he in custody?
He was just arrested last evening.
But he has 2 capious felonies, no bond holds. Are those?
Those are court ordered.
Okay. No, I understand that, but he didn't show up for sentencing.
Yes.
On March 23rd, I see. All right, so court's gonna keep the bonds in place. Court will make the bond on count 3, $499. Thank you, sir. David Michael Johnson, please. And then we have Willie Leonard Worthy. Okay, Mr. Johnson, good afternoon, sir. You have a possession of counterfeit instrument. Court finds probable cause, $1,000 bond. Anybody want to be heard?
Yes, Judge.
Sure.
He's currently homeless, but he's able to reside with his friend at a specific hotel that's Lake Shores. He informs that
In Palm Beach, or is that in Broward?
Lauderdale by the Sea.
Okay, I'm sorry, I didn't know where Lake Shores was. Go ahead.
He'd be able to reside in his.
Also, when I fill out that paperwork, I put
It's okay.
my shelter's address.
Okay.
I can get another.
Shelter's address as well. We're asking that he be given a pretrial release, Judge. As far as culpability, he did work and he received this check for the work from the foreman, and you know, I mean, I understand that's a defense for trial, but there's not a lot of culpability, and I don't think that he's a flight risk because of that. And he starts the job on Monday.
All right, that's for pretrial.
That's what he's saying, standard pretrial.
I'm saying that.
Okay, so you agree?
Yes.
Okay, Mr. Sanders and Mr. Linder agree. Give me his new address, please. Where's he want his mail going? You want me to update it now or later? I just have at large, I'd rather have something.
1445 West Broward Boulevard. West Broward Boulevard.
Wait, 1445, 1445 West Broward Boulevard.
Fort Lauderdale, Florida, 33060.
Is there apartment?
No, it's Salvation Army.
Okay. Oh, no, that's a good idea.
They told me to mind them off the for.
Listen, if he wants to update it, Mr. Sanders, he can.
Yes,
Okay,
Judge.
but you gotta have your case number on it, sir, okay?
Okay.
All right, thank you,
Yes,
good
ma'am.
luck to you. Sir, you're gonna have to report, explain to him.
Hold on just a second. You have to report to pre-trial whenever you get out within 24 hours,
I
okay?
think I have a mouth for me again.
Yes.
Okay,
I can do that.
Thank you, Judge.
thank you. Okay, Willie Leonard Worthy, please.
Yes.
Hello, sir. You have one count of carrying a concealed firearm. Court does find probable cause, bond set at 1,000. Supposedly, this was a warrant. Okay, anybody want to be heard? $1,000 bond?
No objection to $1,000.
Okay, there you go, $1,000. Thank you. Look to you, sir. Hugh Harrington Bakuti.
Hello, Your Honor.
Hello, how are you?
I'm good. How you doing?
Fine, thanks. All right, sir, you have one count of possession of cannabis, 20 grams or less, $1,000 bond. Counts 2 and 3 are not for a magistrate, which is driving while license is suspended without knowledge and a civil traffic infraction, something about headlamps. 2 lighted headlamps, it looks like. I don't know what that is. But anyway, then you have count 4, probation violation or community control. You do have a no bond hold. Court does find probable cause. Can you afford the $100 bond?
Can you afford $100?
Yeah, I can afford that.
Okay, thank you, Judge.
All right, I'll set his bond at $99. Thank you.
What's that mean?
You have to get the no bond hold lifted first.
Give me one moment. Okay, sorry about that. Robert Anthony Buto, B-U-T-O.
Bruto bonded.
Naive Daniel Brathwaite, is that
Here,
correct?
Judge.
Okay. All right, sir, you have possession of cannabis, 20 grams or less, no bond attached to that, possession of drug paraphernalia, that's basically another ROR. You do have tamper with or fabricate physical evidence. Bond is set at $1,000. The court does find probable cause. Does anybody want to be heard?
Judge, based on his lack of priors, we're asking that he be ROR'd on the tampering. He's 18 years old.
I have no objection to that.
Say that again?
ROR, no objection. Since he's 18 years old. Judge, I would like to see if we can divert him to drug court.
Okay, I have no objection.
Can I elicit testimony, Judge?
Sure.
How old are you, sir? What's your name?
18 years old, Naive Brathwaite.
Okay. Do you have a substance abuse or use problem?
Yes, marijuana.
Okay. Do you use every other day?
Yes.
Are you amenable to treatment and services?
Yes.
Okay. And there doesn't appear to be any restitution on this. Asking that we have an order reflecting those findings and pretrial to screen him.
Okay.
Thank you, Judge.
That's obviously up to the discretion of the drug court judge.
Understood, Judge. Just as long as we have the findings, so she's allowed to make that decision.
Okay. All right, thank you. Next one is Tronacious. I hope I'm saying that right. Matthews? Tronacious Matthews. North Broward? Tronacious Matthews? Have they bonded? Do you know where they are, Mr. Sanders?
Sorry, Judge?
Tronacious Matthews.
Matthews? NBB is all it says.
What does it say?
North Broward Bureau.
Oh, okay, thank you. Okay, North Broward, are you there? Hello at North Broward? Yeah, if you can, I'd appreciate it. All right, so this is what we're going to have to do. It's actually his two no-shows arraignments. One says no-show arraignment, the other one just says capious. The others are no bond, yes?
The felonies are court ordered, and I checked in Odyssey. There are competency issues in that case. So, obviously, the misdemeanors couldn't be resolved anyways.
Okay, public defender's gonna have to waive his presence for today. Do you want to?
No.
Tronacious Matthews.
Because I saw that there's a...
Sure, we'll reset for the PM. Okay. All right, so we're gonna reset Tronacious Matthews. Willie, you might want to take this. Call up control. it today. See if, he might be in Judge Bailey. Okay, and then we have Jonathan Robert Tankersley.
Copy, Your Honor.
Okay,
Judge, I have some procedural posture where we left off. I want to update the court.
okay, Mr. Tankersley, welcome back. How are you?
Good morning, good, Your Honor. How about yourself?
Good. All right, so this might be a little bit odd because Mr. Saunders is at the main jail and he's going to be arguing your case. So, Mr. Saunders, what I'm going to do is I'm going to have Mr. Tankersley, I want to look at him and I'm just, just as if you're in the courtroom.
Okay.
Okay, is that all right?
Yes, sir. Yes, ma'am.
All right, so, okay, Mr. Tankersley, can you see us?
Yes, Your Honor.
Judge, if I can address procedural posture
Sure.
that we left off. So it was brought to light that there was some kind of hearing in the division after she had ordered sua sponte at no bond hold. From what I understand is I set him down on the division docket for the 34th day because they did a notice of intent to delay on the 19th of March. The judge denied the ROR and found good cause, which we still don't know what that is, but for whatever reason found good cause to keep him up to 40 days. That's something that may be
Which charge
challenged.
are you talking about now?
I'm talking about the as it was before it was filed.
Okay, this is what I'm gonna do. And let me
Judge,
just,
if I,
no,
if
I
could just-
understand and I'm gonna let you make your argument. And I just
No,
wanna tell you.
I really want to explain what's going on because Mr. Linder made it appear as though the judge knew, or I mean, neither one of us knew, but that the judge knew that the charge had changed whenever that hearing was held. If you look at the information, it was rolled over to the 20th, and that hearing was held.
Okay,
and then on
but
the,
let me
on,
just
at
tell
5
you something. I know the thing,
Okay.
I know what he said, and I'm gonna let you make your argument. But I do want you to let you know, I did speak to Judge Duffy. And I just want you to know, I'm gonna make it very clear. As far as Judge Duffy's order on the aggravated battery, I am not touching her order. However, today we are just here in magistrate on the battery felony, great bodily harm. It's count 7. To my understanding, it's a change of charge for an aggravated battery. And that's what, I'm not ruling on anything that Judge Duffy did. I just want to make that very clear. So having that in mind, I just want to know, just hold on and I'm going to let you make your argument. Is there any objection to probable cause?
objection to probable cause, Judge.
All right, so the court does find probable cause for the felony battery, great bodily harm. So, hold on, sir, okay? Just be patient.
Yes, Your Honor.
All right, so, who wants to go first? Mr. Linder or Mr. Sanders? It doesn't matter to me.
Mr. Linder can go first.
Your Honor, the state's position would be that Judge Duffy's order revoking the bond is attached to the case, not the charge, that he violated his release conditions on this case. And that revocation would apply whether it is an aggravated battery or downfile to a felony battery, because the conditions of no victim contact remain the same regardless of the charge.
Okay, so you're asking?
Well, I'm asking that the court keep him held no bond pursuant to Judge Duffy's previous order.
Okay.
If the court...
Is this a punishable by life offense?
No, it is not.
All right, then the court is not going to do that.
Okay.
That is up to Judge Duffy, and they can address that order that Judge Duffy signed on February 20th, 2018. I am just dealing with the change of charge.
Okay. Your Honor.
So tell me the bond you want.
Your Honor, the state would be seeking a bond in the amount of $150,000, pretrial release with a GPS monitor, level 1, no victim contact. Your Honor, the state is seeking this bond for numerous reasons. One, to advise the court, because it's been over a month since you first heard this case. This is a felony battery where it is alleged that Mr. Tankersley, because Mr. Tankersley believed the alleged victim was messaging ex-boyfriends on her computer, he grabbed her computer from her, then with a closed fist, struck her numerous times on various parts of her body. She suffered bruising on her torso, her breast area, and suffered a significant laceration on the back of her head. A laceration so significant that it required staples to treat. Your Honor, I can also personally advise the court, I have been in contact with Ms. Thorpe from the inception of this case. She is in extreme fear of Mr. Tankersley. She's in extreme...
Objection to proffering hearsay.
Your Honor, I believe the court can consider that for purposes of bond.
Okay.
She is in...
Okay, I'm going to overrule the objection, but go ahead.
She's in extreme fear for her safety. As Your Honor, as is indicated in Judge Duffy's previous rulings, Jonathan Tankersley ignored Your Honor's order to have no contact with the alleged victim, and while in custody, called her numerous times. This has increased her fear of what will happen if he is out of custody, since he won't even follow a no contact order while in custody. Your Honor, I can additionally advise the court that at the time Mr. Tankersley committed this offense, he was out on pretrial release for a DUI in Broward County. Your Honor revoked his pretrial and gave him a $1,000 bond. I can tell you, and I've only had a brief, I haven't had much time to review. I'm going to advise the court while I'm reviewing it right now. As far as his criminal history, 2010, he was convicted of a felony domestic violence battery out of Dade County. In 2006, and I apologize that I'm not going to be going in order of when it occurred. I'm reading it as soon as I see them. 2006 in Dade County, a withhold on a grand theft auto.
Stepfather's car.
He was arrested, and Your Honor, I believe...
Okay, sir, please don't talk about the facts of the case. I'm sure that Mr. Saunders would tell you that too. Correct, Mr. Saunders?
Correct, Judge.
All right, go ahead.
Your Honor, and I want to advise the court, based on the nature of the relationship between the parties in this case, I believe I am required, pursuant to state statute, to advise the court of all arrest. And the court, it's up to Your Honor whether you want to consider them or not.
Okay. What are the alleged victim's initials?
CT.
Okay, go ahead.
Your Honor, he was arrested for a battery in Dade County in 2006. That was dropped. He was arrested for another battery in 2007 in Dade County. That was dropped. He was arrested for another battery 2014 in Dade County. That was dropped. He was arrested he was convicted in from a 2014 burglary of conveyance, grand theft, and theft. That was out of Dade. In 2016 in Dade, he was arrested for aggravated battery. That was dropped. He was convicted of 2 counts of battery, 1 count of assault.
Judge, this is a domestic violence charge, and so I ask that you not take any of the drop charges that, the numerous drop charges that were just listed into consideration at all. Since there was no conviction in them and they're merely arrests, you can't use those. I think that if it's a domestic violence charge, he would be able to obligated to read those, but it's not. This is a 3rd-degree felony, so I ask you not take any of those drop charges into consideration in our system of justice.
Okay.
Fine, Judge. I just ask the court to take into consideration the priors that he has been convicted of, including crimes of violence, including a felony-level crime of violence. Your Honor,
what was a felony-level crime of violence?
He had a felony battery out of Dade.
Okay, simple battery, touch or strike?
Your Honor, I advise the court, and I'm just going to continue making my argument to the court.
Okay, let him finish, Mr. Sanders. I'm going to certainly let you finish.
So,
go ahead.
Your Honor, I'm asking for these conditions. 1, based on the level of violence. 2, I have no confidence that Mr. Tankersley will follow the court court's order of no contact. And because of his prior history of violence, my concern is that should he continue to violate a court's no contact order and even go so far as to make contact with the alleged victim, I have significant concerns for her safety. And my other concern about him not following the court's orders is that he already violated his pretrial release conditions on this on his other case in Broward County just based on this arrest. Nothing further, Your Honor.
All right, the court is going to order, I will tell you this, no victim contact, direct or indirect, with the alleged victim, CT. And sir, that means no calling from the jail, no writing from the jail, whether you're in or out of jail, I should say. So that's no contact in person, calling, texting, social media, liking, disliking, or any contact through third parties. Do you understand?
Yes, Your Honor.
All right, and that's with the initial, with the victim with the initial CT. Go ahead, Mr., is there anything else?
Nothing further, nothing
All
further,
right,
Your Honor.
so, sir, hold on one moment. I'm going to go to Mr. Saunders, okay?
Yes, thank you, Your Honor.
Okay, so let him finish his argument. Go ahead, Mr. Saunders.
Judge, this has been downfiled, so I'm asking that you give it the same bond that it had as a second degree as it's now a third. Now, the allegations are still unproven. It's one-sided version of the story. Since the state proffered, all proffered that they engaged in intercourse after this alleged incident, and that it's likely motivated by the fact that he was involved in an accident that she was the driver of, and he filed a claim with her insurance. I'll also proffer that she jumped on top of him and injured his private parts, and the reaction from that is what resulted in the laceration to her head, and that this was a late filing because there wasn't an issue, knowing that it was an accident, until he filed a claim for her car insurance and automobile insurance. So there's definitely motivations there that are going to be...
Please let your attorney finish.
There's definitely motivations on both sides, and this will likely be fettered out in trial, maybe a stand your ground hearing, maybe not, but the merits of it are only one-sided before the court. I'm asking that he be given a meaningful opportunity to pretrial release. I ask that you take into consideration that it's been downfiled from a second degree, and it's now a third degree, and instate the same bond, $20,000, which he was going to post before. If he didn't learn that he can't contact her before, he sure knows now. And contact wasn't violent, it was just over the phone as the case law that I presented to you. Trying, for whatever reason, I guess, figure out what was going on. But that aside, that doesn't create physical harm to the community. Physical harm to the community is the constitutional factor you have to look to. And physical harm to the community wasn't listed in any forcible or violent past. Everything that it was listed off as convictions by the state, none of which were violent. Touch or strike battery is not violent. We have to assume the least culpable conduct, and that would be touching somebody against their will. So as it lays before you, he's not a violent person, no matter what the arrest records are. I understand the GPS monitoring. I'm asking that it be a curfew or in the alternative level 2. Understanding that if he has that a reasonable bond could be put in place, maybe $10,000, because as we all know, money doesn't create safety to the community. Tracking does, and if we're going to track him and he's going to have this extra level of supervision, I ask that he have a reasonable bond in the amount of $1,000. And lastly, I'd like to elicit testimony about his ability to pay, just for the record, if that's okay, Judge.
Sure. All right, let me switch to him so I can look at him, okay? Okay. All right, Mr. Tankersley, Mr. Sanders at the main jail is going to be asking you some questions. Okay, sir? Raise your right hand. Do you swear and or affirm to tell the truth?
Yes, Your Honor.
Okay. Your name is Jonathan Robert Tankersley?
Yes, Your Honor.
All right, put your hand down. Go ahead, he's under oath.
Sure. How old are you, Mr. Tankersley?
35.
How long have you lived in South Florida?
My whole life, sir.
Are you currently employed?
I part-time with my mother in TV production.
Have you been working the last time, 30 days? How long have you been incarcerated, sir?
Been in custody now 45 days, over 45 days.
So has that affected your substantially affected your financial ability?
Yes, sir.
Okay. Can you, would you be able to make a $10,000 bond?
My mother might be able to, but I have a 4-year-old daughter.
Understanding that a 10% would be $1,000.
Oh yes, I can afford that. My mother will help. I'll pay her back.
Could you afford more than $20,000?
I don't think so. So no.
Okay, and that would be a substantial hardship. Even to do the $20,000, that'd be a hardship on your family.
Yes, sir.
Okay, and you understand that you're to have no contact, indirect or direct, with the person that has made these allegations until you have your day in court. Is that understood?
Yes, sir. I apologize. I had no idea the allegations until
until the day of court. Understood. No further questions, Judge.
Back to you, by the way, so you know. All right, so I'm also reading the Pembroke Pines Police Report. All right, State, anything further?
Nothing further, Your Honor.
I'm assuming you have nothing further?
Nothing further, Judge.
All right, this is what the court's gonna do. Based on the totality of his circumstances, I want no victim contact, direct or indirect. He's not to possess any firearms, ammunitions, or weapons. If he's released, he's to surrender any to his local police department immediately upon his release, if he hasn't done so already, or if he does possess any. GPS level 2. This, of course, is without prejudice for him to go before his division judge, but based on the allegations and everything else in this case that I see in the court record over here, the court is going to do a bond of $150,000, and that is without prejudice.
Judge, that would be tantamount to no bond.
He's
not going to be able to get out. And we already see where his division judge pre-inclinations are going to be to pretrial detention. If he can't make that bond, he's going to be subject to pretrial detention.
All right. I'm sorry, respectfully, I understand your argument, and based on the totality of the circumstances, I am going to do the $150,000 bond. It is without prejudice. I understand what you're saying. You can file whatever appropriate motions before Judge Duffy.
Judge, are we back at 1 or 1:30?
Hold on one second. They're asking something. What? Okay, he's to maintain 1,000 feet from the alleged victim at all times. That's what I initially did, okay?
Yes, ma'am.
Yes, we're back at, actually, Mr. Sanders, at 1 o'clock today, unless you want to take a little bit longer. It's almost 12.
Okay, thank you.
So when do you want to be back? Oh, actually, today I do the extraditions, but those go fast. We only have 4. So if you want to come back, I'll be here at 1. So whenever we're done, we'll begin, or if you want to be back at 1:15.
I'll make it there. Okay,
Okay, thank you.